Why don't you go see your boyfriend?
Yeah, he's got a nice room. He won't have it long. He'll have to call for 7 a.m.
See if we can figure out something.
Listen to a puzzle.
Hiya. I was first. Do I get a cookie? Sure. You get a virtual cookie. Maybe we need a set time to start like a TV program. Oh, Little Miss, if I could organize my life a bit better, this fringe is just not it today. If I could organize my life a bit better, then I'd probably be able to have a set start time. However, I have a day job and an upcoming wedding and an annoying amount of life admin, like the broken tooth. And today, my lunch break was taken up by reporting a fake version of a product I love. So that was fun. Anyway, before they end, I want to quickly hop over to Judge Webster. Well, no, let's go to Judge Washington first, see if she started again. She has in person. So she's there talking. Okay, we're going to hop over to Judge Webster.
10 a.m. I'm going to leave it at status control. First appearance scheduled June 20th. Yep. That's what it's going to be. I want you and Mr. Levitt. I want Mr. Levitt to have time to get his discovery, to talk to you, to get his defense determined, and see if he wants a trial or not.
Okay, thank you, Your Honor.
There you have it.
All right, thank you.
Continued on bond. Nothing further, Mr. Regier?
Not in this matter, Your Honor.
Oh, that's the other thing I did today. YouTube sent me an email saying that I've reached the 3 to 4 weeks since they posted my sim. Oh my gosh, this is crazy. 2 months. It's been such a fast 2 months. That is wild. YouTube sent me an email saying it's been 3 to 4 weeks since they posted by snail mail my PIN to prove my address. Now, there's 2 problems. 1, my house number is not on it, and I tried to tell them that. And 2, in South Africa, we don't really have snail mail. It doesn't exist. Floating heart. Thank you. So I spent an extreme amount of time talking to YouTube support, and basically they came back and said that it hasn't been 3 to 4 weeks, and I have to wait the 3 to 4 weeks in order to be able to request again. So that was a huge waste of time for me. Let me just turn off this floating heart before I forget. And turn this on this. Okay, save. That should be like that. Heart should go away now. No, that's not where we are. This is where we are.
Thank you, Your Honor.
You're welcome.
Have a great day, everyone.
I'll have to look on the normal stream. Oh, yeah,
Am I
it's
free
the
to,
two.
am I free to go, Your
You
Honor?
can go, Mr. Ernest, but you get a hold of that attorney.
Thank you very much.
Jerk me around on this end one more time.
Will do. Absolutely.
Wait, did they speak to him already? I went back way too far. I'm so scared they end the stream.
Mr. McGee, is that right? You plead guilty? Ability, right, if you need their online over to November.
Okay.
Figure out what to do with this kid.
He's not on there anymore, is he, Jim? That, I remember that one.
The warrant has
Fourth, you didn't have to
Was that because of
Okay.
Ernest on the record in 2023 TR 1225, State of Kansas versus John Kelly Ernest.
Yes, ma'am, I'm here.
Jared Regier for the state, defendant Mr. Ernest in person,
Yes, ma'am.
and per se.
Yes, ma'am.
Court security, did you get, never mind. You're gone. Did you get the Reed defendant in with Mr. Patterson?
Yeah, well, I think she's in there right now. And that subject that you asked about the warrant has already been served on it.
Okay. Was it an active one at the time?
They said he's already been served and processed on it.
Okay, good
That's
deal.
all I know.
Good deal. All right, thank you. Okay, so John Kelly Ernest is here in person and Jared Regier for the state.
Yes, Your
Mr.
Honor.
Ernest, you have one count of DUI. We've had multiple hearings, including a date for bench trial, but that was set over because you were going to hire Matt Levitt. And then you came back on the 24th. You didn't have diversion. You wanted more time to hire Attorney Levitt. Then we came back August 12th and you owed Attorney Levitt 200 more. But if I would just set this over to August 26th, you would appear with your attorney. So what's up?
Yes, Your Honor. Well, the only thing that I didn't realize was that because of my mother's passing, I had missed a week and a half of work due to that situation. And so my paycheck, when I got it, I didn't have enough to finish paying him. So I need this Friday's paycheck to pay him, and then I'm done. Or if you just simply are frustrated with me, Your Honor, I understand, and you just want to go to trial, I'll accept that as well.
Well, I have to admit, I'm frustrated because this is the 5th hearing. You've been telling me you were going to hire counsel.
Yes, Your Honor, I totally understand. I have no issue whatsoever with what you're saying. I knew you would say that. I just did not realize that I would be short a paycheck. I didn't know that. I should have known that, but I didn't.
Counsel from the state, your position?
Well, Your Honor, going back to my notes, in this case, it would appear this matter has been set for bench trial multiple times. First time back in November of 2023, it looks like the defendant failed to appear. The second time, it would appear that back in April of 2024, so maybe 4 or 5 months down the line, it would appear the defendant made certain allegations as he appears to be making today. I, of course, have no personal knowledge as to that. And in the intervening time, it would appear that there's been multiple control hearings since that earlier April 10th date. And
Yeah,
so
a whole lot more. After you started speaking, I found a whole other page.
Yes, Your Honor.
so
Go ahead, Mr. Regier.
So I'm not quite sure how the court wishes to proceed to that. It would appear that this case has remained in limbo for quite some time. If the court will pardon me for editorializing slightly, what I can tell the court is that the state is most eager to reach a resolution in this matter. In reviewing the information, this case does appear to be quickly approaching the 1.5-year age mark. Count 1 of the information does appear to allege a date of March 25th of 2023.
Well, and council, we both know from experience that even if he comes up with the 200 and hires Mr. Levitt, Mr. Levitt's gonna come in and ask for continuance because he's just been hired.
You know, Your Honor, I would almost just ask you to please just set a trial date. And I will work it out with,
I've done that multiple times in this case, then you come in for trial and you're not ready.
yes, Your Honor. I know my circumstances are less than perfect, and I show up here and I tell you the reality. I can't do anything else. Trust me, I want this resolved as well.
I'm gonna set this over to November 18th, 9 a.m. I'm gonna leave it at status control. Don't think that gives you till November to come up with your 200 to hire Levitt.
No, I was hoping you'd say an earlier date, but
Yeah, that's what it's gonna be. I want you and Mr. Levitt. I want Mr. Levitt to have time to get his discovery, to talk to you, to get his defense determined and see if he wants a trial or not.
okay, thank you, Your Honor.
There you have it.
All right, thank you.
Continued on bond. Nothing further, Mr. Regier?
Not in this matter, Your Honor.
Thank you, Your Honor.
You're welcome.
Have a great day, everyone. Am I free to go, Your
You
Honor?
can go, Mr. Ernest, but you get a hold of that attorney.
Thank you very much.
Jerk me around on this end one more time.
Will do. Absolutely.
Is everybody else, Mr. Patterson? Oh, here, Gersh. Will be on the record in 2024 TR 875, State of Kansas versus Sarah Esther Gersh. Jared Regier for the state. Is Sarah Gersh here? Is that you waving your hand under Roseanne Powell? Can you click on that little red icon that looks like a microphone?
Can you hear me now?
I can, thank you.
Okay, yes, I'm Sarah Gersh. I'm currently in inpatient drug treatment at DECA in Wichita, Kansas.
All right, Mr. Regier for the state. Ms. Gersh appears in person and pro se on one count of operating a motor vehicle without a valid license in Butler County, Kansas on February 3rd, 2024. You had first appearance scheduled June 26, 24, failed to appear. Had first appearance rescheduled July 3rd, 2024. You appeared from the Butler County Jail and had your matter set for August 26th with an order that you must appear at the Judicial Center. August 21st, 5 days before you were ordered as a condition of bond to be in court, you called the clerk of the district court and said you wanted to reschedule because you were currently inpatient.
Yes, ma'am.
Explained that you were on bond and that you would need to appear. And here you are. So you haven't been in treatment but just a few days, so.
No, I leave the 29th. I'm already graduating. I graduate this Thursday and move into El Dorado to the sober living house. Second chance.
What do you want to do about this charge of driving without a valid license, a class?
I want to take my written and my driving test, but I need a vehicle. I'm sure when I get to the sober living house and start my outpatient, I can use my dad's van because they have insurance.
All right, but I'm not I'm not here to judge you on what you do in the future. I'm here to
Okay.
judge you on what you did on
Okay,
February 3rd of 2024. How do you want to take care of that?
I'm guilty.
You want to enter a plea to this B misdemeanor?
Yeah,
Do you want to talk to an attorney first? You can hire,
no,
you
no,
can hire any attorney of your choice. If you cannot afford an attorney, you can apply for court appointed, and if you qualify, one would be appointed. Or you can waive your right to an attorney and represent yourself. So how do you want to proceed?
I'll represent myself.
And now you understand you can hire or apply for court appointed. Is that right?
Yes,
And knowing that, you want to waive your right and represent yourself.
yes.
Is anyone making you waive your right to counsel?
No, ma'am.
All right, I'll have the record reflect that you are freely and voluntarily waiving your right to counsel and that you know your rights in this regard. How do you plead to operating a motor vehicle without a valid license on February 3rd, 2024 in Butler County? Again, a Class B non-person misdemeanor.
Guilty.
You're admitting that you did drive without a license?
Yes, ma'am.
Again, is anyone making you enter this plea today by any threats or promises?
No, ma'am.
You understand you're giving up your right to a trial and will be convicted and unable to appeal the conviction?
Yes, ma'am.
And where were you driving on February 3rd in Butler County?
On Santa Fe Road and right outside Douglas, Kansas.
I will have the record reflect both in the journal entry and the docket notes that you've waived your right to counsel
Okay,
and that you entered a plea of guilty. Recommendations finding the defendant guilty of driving without a license. Recommendations for sentencing, Mr. Regier.
Yes, Your Honor. The state would recommend at this time for the sole count presently before the court, a $100 fine, $108 court costs, 120 days underlying sentence, and 6 months of non-reporting probation. The ticket in this matter does appear to refer to a certain location on Southwest Santa Fe Lake Road. I have not had the opportunity to verify that as being within Butler County at this time. However, if the court wishes to grant me approximately 20 seconds, I am in a position to do so if the court wishes to do that before proceeding.
Sure, go ahead.
Thank you, Your Honor.
You're welcome.
Yes, Your Honor, if I may.
Go ahead.
Your Honor, the ticket does appear to refer to a location on Southwest Santa Fe Lake Road, specifically 16,500 Southwest Santa Fe Lake Road. The state's understanding is that is in Butler County at approximately a triangular location between Rose Hill, Douglas, and Augusta.
All right. At this time, Ms. Gersh, you are fined $100. Your assessed court costs of $108 for a total of $208. How much time do you need to pay that?
At least like 3 months. I got to get a job when I get out of here.
I'm in order that you pay within 90 days. Your jail sentence is 120 days. That will be suspended for a 6-month non-reporting probation. If you don't want to serve the 120 days, make sure that during the next 6 months, you violate no laws, that you get the $208 paid within 90 days, and I'm also ordering that you get your driver's license reinstated.
Yes, ma'am.
So like you said, when you get out of treatment and into the sober living or halfway living, or halfway house, you better get to work on that driver's license.
Yes, ma'am.
Anything further, Mr. Regier?
Your Honor, if the court is ordering that the defendant obtain a valid driver's license, is the court ordering that the journal entry reflect that, and second, is the court saying a specific time frame for that endeavor?
Within 6 months.
Very good, Your Honor.
Okay.
Will now be on the record, and Scott, and you are
Okay, two things. One, hi Laura. Two, hi Donald. I actually meant four things. Three, I need to switch over to Judge Washington before she removes this. Where's the start? And four, I need to call my nephew for his birthday. So I'm going to step away briefly. Oh, come on. Didn't start that long ago, did it?
Pretty just for the people.
Assistant Public Defender Allison Muller here on behalf of Candace Anderson, who will be seated here to my right. Miss Anderson, can you state your name, please? Candace Anderson.
We're here for sentencing today.
Yes, Your Honor.
Did you have to review the report with your client?
I have, Your Honor. As far as the factual part of it, we have no corrections, modifications, or deletions. I would like to address the recommendation.
Thank
When
you.
appropriate.
Ms. McDuffie?
Your Honor, there's a lot here. I know that our complaining witness is present. Is the court in receipt of the document that we received from him as well?
I am, and I've read all of the pages and every sentence of that report. I am very familiar with it. Thank you.
So I don't even know what else to say, I think, honestly, beyond that, except that this would be disturbing enough if this were like a first offense, because it would still be a very, it's clearly not. And it's one thing when someone, sort of believes that they're being told what they did and thinks that that's not the person I want to be, but not really getting, this is familiar behavior. This is in some ways frequent behavior. We just have a reference to the previous case that happened to involve a firearm, but there are several other assaultive incidents that weren't even, mentioned in Agent Johnson's report. And even the prior probation that she was on was violated with some of those things. I don't comprehend. I know that we get to this place so often, and especially when defendants are in person and fully realizing the consequences that probably await them because they're in person. And it is that time when everything spills out about all of the consequences that they might have to suffer with their work, their employment, their children, and it just baffles me how none of those consequences are considered before they decided to act in the way that they did. This was not, everything seems so much of a choice, so much of an intentional choice. And there was every opportunity to not behave in the way that Ms. Anderson did in this incident. So we are now faced with not having to meet those consequences because of concerns of family and home and other obligations. The people that are threatened with firearms and death threats and comments about body bags, the people impacted by this behavior have those concerns too. Not to mention in that immediate moment, the concern for their own life. And to hear all of that reduced to this was a private family conversation, as if I don't comprehend. I do comprehend it. Actually, I think the problem is that we all comprehend it and Ms. Anderson probably doesn't. So I don't want to go on too long, but as I started out, this is not the first offense. This is not the first time. This is not a situation where, not that this is ever an excuse, but this is not a case where tempers flared and someone's emotions got the best of them and they might have been under the influence and didn't appreciate the nature of their actions. These exact actions have been demonstrated before with an entire term of probation in this court years ago. I don't understand, and I never will understand, how we are sitting here today with a similar set of circumstances, if not worse, quite frankly, after that time. And in that previous case, Miss Anderson's child was in the car when that firearm was pointed at somebody. So there's just an entire other layer of The same children that we need to be concerned about today in terms of her not wanting to go to jail, to need to be there to support them, they are exposed to this behavior. What are they supposed to think? I'm going to stop and ask the court if it's prepared to hear from Mr. Wilson.
I am prepared.
Sir, if you can please unmute.
Good morning.
Good morning,
I've never had the pleasure of speaking with Ms. Duffy. What she said is the whole cake, the icing. That's exactly my sentiments. I don't know if Candace can hear us at this moment, but that is
She
my
can't,
exact.
she can hear you, sir. She can hear you very well. And in addition to that, I don't know if you know, and it's completely up to you, and you can remain off screen if you so choose. But your camera is not showing. I don't know if you want your camera to show or not. It is your choice. You don't have to turn it on.
Good morning. I'm sorry.
That's okay.
So, Mrs. Duffy's perception of this is my exact perception. This was not a personal family issue that happened. This is something that my sister created, and she's upset. She was completely surprised that I showed up to the first hearing, which I don't understand why. She threatened to murder me over 3 different occasions, aside of the gun situation. And I had nothing to do with this situation, ma'am. She disrespected our grandmother to the fullest extent, and my grandmother asked me to stay out of it. She said, don't say anything to her. She's looking for a fight. I didn't say anything to her. 4 days later, after the incident, I received a text message. F you, F y'all can die with her. She can die with her husband. And mind you, I didn't even say anything to her. I didn't call her. I didn't text her. I wasn't talking bad about her. I didn't say anything to her. I stayed out of it. I work a full 9-to-5 job, and she texts me at 2 p.m. With all these vulgarities. So I don't know where this is coming from. So I called my brother, and my brother stated that they had got into an incident, and I still wasn't. I'm like, did my name come up? And he said, no. I still am unclear how I was in this situation. To be put in a body bag before this situation happened, me and my sister were on a good page. I help, not even help take care of her. I wouldn't say that, but more so I'm there for my nieces. I'm a good uncle to my nieces. I'm a good brother to my sister. So she doesn't understand or comprehend. Maybe she doesn't comprehend the severity of this, of threatening to murder. She threatened to put me in a body bag. Then she came over and was yelling in my grandmother's face, asking if she had life insurance on me because of something that she created. Nobody put their hands on her. Nobody said that they were going to do anything to her. This is all in Candace's head. Like and then this is ongoing drama. Even now, she's telling people, don't talk to me. And, oh, he came to court on me. And that's not my brother. And like, we're blood. We came out of the same woman. And all of this for something that Candace created. This is everything. This is happening. Candace created this. She cussed out our grandmother and wanted me and my brother to be on her side with that. She's talking about she take her husband off, like, and it's not even that our grandma chose her husband. Like, as an adult, you have to grow up and realize that everybody has their own life. We are not our grandmother's children. My grandma stepped in because we had an absent mother. She was there, but she wasn't an attentive mother. But Candace is 29 years old. We have to let those things go. We have to let that go. She has 2 children that she needs to be concerned about their welfare and being a better mother than our mother was. But creating family drama, threatening to kill her brothers, like, and let's say hypothetically she did kill off her brothers, what would that resolve? What would that resolve? So it's ongoing, and it's getting worse and worse. Yes, me and my sister have got into altercations. Yes, that's what families do. But it's never been to the extent of, I'll murder y'all. I'll put you in a body bag. Y'all some pussies. Y'all scared of me, coming around flaunting her gun. And I remind you, Judge Washington, over something that she created. So I'm going to leave it there. What Miss Duffy said, I'm just as baffled as her. And I some type of mental evaluation needs to be addressed. And I wanted to continue the no contact order, period.
Thank you, sir. Ms. Muller.
I appreciate Mr. Wilson's statement. And I think everything that Ms. McDuffie said rings true. I think, and I've spoken with Ms. Anderson several times, she was concerned after talking with probation. She realized it didn't go well. I think she regrets not taking more accountability and giving a more open assessment. Obviously, it's very concerning what happened. When I've spoken with Ms. Anderson, and this isn't an excuse, I'm just trying to understand where she was, kind of why something like this could occur. And I did send documentation to the court about her toddler who's outside right now, does have pretty significant health issues. Around the time of this offense, her daughter had.
She knew that at the time she did this.
Your Honor,
and I know she knew that because I put her in jail the last time she was before me and told her very clearly not to come back. And instead, she's back while making threats and telling the people that she has threatened that they're pussies for calling the court in. Ma'am, I can see the text. There's a text message. I have the text message. So I think you better recount your statements. I'm giving you an opportunity to do that is why I'm telling you this. Because she is not telling you the full story. She is very aware that she had a gun the last time she came into my courtroom. She is very aware that I gave her an opportunity on probation. She is very aware that she violated that probation that time and ended up in custody. So apparently jail is not that serious for her because she's back here now, and I see it very differently. I see everything that Ms. McDuffie said, but I also see a continuing pattern of taunting and threatening her family members. So it's going to take a lot for me to understand the frame of mind that she was in. Now you may proceed.
Your Honor, I understand, and I agree with you. I'm struggling also to understand, and so I only mentioned that, and she had had a miscarriage as a way of saying, I think there is something going on, maybe mentally here. I'm not sure. I think that part of the recommendation, I think obviously full agreement with. I think there needs to be some kind of help. She needs counseling. We need to understand what's going on, what's causing this, because as the court said, this isn't typical behavior. This isn't, when you're on probation, you've already known what's happening to kind of escalate behavior in this way. So I agree with that. And I share the same concerns. I just wonder, as I do in many cases, if the 30 days in jail will, or it could be the full, of course, as well, what the jail time will serve for her or for her brother, who is the victim in this case, or her other family members. So that's my only concern, or just questioning. I don't know what more can be done, but I do. The probation last time didn't work. I hope the probation here will work. I hope something will click for Ms. Anderson. She knows what she stands to lose. She said that her and her grandmother are the only ones who can care for her daughter. She knew that when this happened, as Your Honor said. That should have been her top priority. I think if it wasn't, it is now. I think she needs help. I hope she gets that as part of this recommendation. And so I would argue against the jail time only for the reason being I don't know what it will change in this matter, but all the other recommendations, giving up all firearms, absolutely, getting the mental health that she needs. I think, and Mr. Wilson kind of alluded to, maybe the way they grew up, and that's not an excuse for any defendant, maybe past family traumas, but it sounds like there's a lot here, maybe things she went through, and now she's creating the same circumstances that maybe even she grew up with. And so that would be my only request, if there is any leniency to reduce or hold this jail sentence in abeyance so that she can get the help that I think she probably needs.
Ms. Anderson, what would you like to say, ma'am? You see how I feel at this point?
Yes, I really want to apologize. Just was going through a lot. My daughter had surgery. She had her tonsils took out, and I woke up and she had like blood coming out her nose and her mouth. So she had a blood clot that had bust. So we had to go through surgery again. So it was a really hard time for me. This all happened in April all in one time. We get out the hospital. My grandma does help me a lot. And then I turned around like a week later and I had a miscarriage, probably due to so much stress. And I was just going through a lot. I didn't mean to take anything out of anyone. I would never harm my family or put my children in harm's way. But
You wouldn't put your children in harm's way. We've seen you do that before already. And this baby that has the disabilities, that's the baby that you were in jail. You were pregnant then and in jail with that baby, right?
I believe so. Yes.
And you're telling me you wouldn't harm anyone when you walk into a kitchen with a gun and you don't want to put your children in harm's way. You are the harm.
I'm trying to work on myself.
How?
I've been taking my medicine. I take Lexapro. I've been taking my anxiety medicine and my depression medicine. I just have a lot going on. It's
You
hard.
recall when you were here last time? What did I tell you?
I'm aware.
And I say don't come back?
Yes.
I specifically remember you because you were one of the first people I had ever had to put in custody.
Sorry.
And you, in that particular case, you were in relationship with someone who had a wife. You find them, pull out a gun on them. Did that not happen? And so you apparently think that threatening people with weapons is the thing to do.
No, ma'am.
No, obviously you would, or you wouldn't be here again with this same charge, ma'am. And you had plenty of time to think about it. You had days. This was a matter of days of you taunting your family, making your family feel as though you might kill them. I'm sure your brother has all kinds of emotions going on right now, seeing his sister in this position, and he has to write letters to a judge, talk to a prosecutor so he can feel safe from being around you. So now he's got that trauma that he's got to deal with for the rest of his life because you are creating this circumstance. Because apparently you didn't learn a thing the last time. And your attorney's saying that 30 days is not going to do anything for you. I think she's right. But only because, in reality, I don't know how you got here with just a misdemeanor assault and battery. I think you're not going to learn a thing until you spend some quality time in jail.
Understand this question?
You're trying to punk your family with a gun? Who does that? People who kill their family members do that. That's who does that. So I feel like I need to protect them from you. Because if I don't, you turn out to be one of those stories where you've gone in and killed up a whole household and your kids too, then I'm the bad guy. Anything else before I impose sentence, ma'am?
Your Honor, understand the court's concerns and that. Your Honor, I understand all of the concerns present today and the safety concerns. I would ask that the court is considering jail a shorter term with release just to a home confinement GPS tether. Or if Ms. Anderson can get some time, I believe she's been doing so, but now she's worried that maybe she hasn't filled out all the necessary documentation if her daughter needs any kind of care in the immediate future, that that someone else has the authority to bring her in for her to get that care. So I guess it's a either or two-part request. If she is going to turn herself in, that she be given maybe time, a short span to do so, or that she either receive limited jail time with only release to a home confinement.
Both of those requests are denied. Ms. Anderson, it is the sentence of this court that you serve 93 days in a Washington County jail. Credit for the 1 day you have served. You're gonna serve 30 days immediately. If I had more time on this sentence, I'd give you more time than that, but I don't. Because I just don't understand. I can't fathom you being the person that you are right now. And you come before me asking me to do something to help your child. I think helping your child looks very different than what's actually gonna happen. Because what kind of mother does these things to their grandmother and to their family? The grandmother incident, the child was present, right? Who does this? The balance is to be served, to be suspended. You're on probation for 24 months. Fines and court costs in this particular case for a total of $525. $30 per month probation oversight fee. You're to meet with probation when and where directed, including any and all home visits. You're to make earnest efforts to maintain legitimate employment. No assaultive or threatening behavior towards anyone. Not your grandmother, not your brothers, not anyone. You're to have no contact with DeAndre Wilson whatsoever. He wants no contact with you.
He'll contact my daughter and like pick her up. That's still okay.
He can make contact through a third party to take your daughter, but not with you.
Oh, that's what I'm saying. Like he
Yeah.
calls her phone.
Yeah.
Okay.
And you know, this thing about the trauma in your family and how that might be affecting you. Your brother went through the same trauma, but he doesn't treat other family members like this. That's a you thing. That's not a PTSD part, that's not childhood trauma. That's you making these choices. And maybe you're very angry about the way your life is going and the life choices you're making right now. But these are your life choices. You need to choose to do better. Maybe thinking about this will get you in a different place. Because I think the last time I put you in custody, it was only like 10 days. You'll have 30 days to think about it this time. And I hope it truly makes a difference for you. I am absolutely shocked and appalled to see who you are being after the last time I saw you. That was about 3.5 years ago. So I clearly remember you very well, and I haven't pulled a file. No going to his place of residence or his place of employment. You are to complete an updated mental health assessment with the mental health provider and sign a release of information. You're to surrender all weapons to the Washington County Sheriff's Department within 24 hours of your release from custody. Any positive alcohol or drug test will result in you getting services through community corrections, outpatient programming, and or additional jail time. You're to be responsible for random drug and alcohol tests as requested by the court, probation, police, or any treatment provider for a minimum of 2 times per month. No use or possession of alcohol, marijuana, medical or recreational, drug paraphernalia, no being in the presence of anyone using them. No use or possession of any firearm components, ammunition, or other dangerous weapons. And I want you to write a letter that goes to the probation department, apologizing to your brother, apologizing to both your brothers for that matter, apologizing to your grandmother, and apologizing to your kids.
Yes, ma'am.
And then you need to figure out why you think this is okay. Is being a bully, that's who you want to be in this world?
Okay.
Or you mess around and hurt your kids because they don't comply with your bullying? You know, telling them that y'all scared of me. Who's not scared of somebody running around with a gun? Normal people are. That doesn't make you bad because you're running around with a gun. It makes you a bad human being, not badass. Those are different things. Why do you want to be that anyway? You had days to think about this. So you sitting here telling me that that's not what you want? I don't buy it. It's what you did the last time when you pulled up on somebody. We're just all lucky you haven't hurt somebody in that moment, that time when you want to show the world who you are. I hope you change that. Because otherwise you're gonna have children whose mom is in custody behind bars for the rest of their life when you mess around and hurt somebody. So please figure it out. We had a similar conversation last time, so I'm not convinced that it's gonna make a difference for you. But at some point, I hope that it does. You sit here and I look at you and I know you can do better. So you need to figure out why you're not doing better or why you think this is the way you should be. Yes, ma'am. I'll see you back here after you get out. I'm gonna see you in about 15 days after that. So that's gonna put us on October 21st, 2024 at 10 o'clock. No, I'm gonna make you come in person again at 11 a.m. in person. I'm sure the same people that you've been abusing over this time period are gonna be the same people that have to take care of your baby while you're in custody for a while. I hope you get it this time, Ms. Anderson. Please go with the officer.
Is it okay to my daughter?
Text your daughter.
Is it okay? She's out in the hall.
No, you need to go.
Yes. Okay.
If you want that to go out to them, we'll get that to them. But right now,
So I can't take it to.
no,
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 you
you're not leaving the courtroom.
You know what I'm saying? Can I take it with me so I can?
You can take it with you, sure. You won't be able to use it. You'll be able to get numbers out of it. Okay, so that you can call people.
Okay, thank you.
Got it so far. I need
Call the case of the state of Michigan versus John Tavis Hayes, case number 23S00438.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of John Tavis Hayes. Mr. Hayes, once you're unmuted, can you please state your name?
John David Hayes.
All right, we're here today for sentencing and bond violation. He has a competency exam going on in the felony court case. What's the status of that, please?
Your Honor, I don't see the competency results, but I do see that the exam was held and he was bound over. So but he was found competent on July 11th. I figured that was the case since he had an exam.
All right, thank you. All right, so we're able to proceed with sentencing on this case? I mean, a violation of probation, I think is what it is.
The
Was he
case actually,
not sentenced as of April 15th? He did not get sentenced.
he did
was
not.
here.
I actually have I was holding on to the victim impact statement to read into the record because the new case came up with the same.
Are you ready to read the victim impact statement at this time?
I am, Your Honor. I'm assuming that the rec may have changed given the circumstances too, because we got that obviously back in April prior to the new case as well. But I can read that statement.
For 1 second. Which agent's case is this, please?
That's my case, Your Honor.
All right. Is the recommendation going to be changed at this point?
It probably will, given that he's in custody of the new felony case.
Do you need time to see him again, or are we ready to proceed today? Where are we with this?
I can look real quick. I believe, let me just. I'm just pulling up his jail information real quick, so I apologize. He does have that pretrial for the new felony matter scheduled for the 17th of September. Looks like he's been in custody for 105 days. I believe our case is a year charge. We can have him do the MRT.
I may proceed.
Okay. I'm pulling up my original report on this, Your Honor. Recollection.
We do have, I believe we had something.
$1,129, what the recommendation was for?
We can have him do the MRT program in the jail and have him pay restitution for the matter, and then let circuit court deal with him. And then once he's done with the MRT program, we can close our case out minus the restitution.
Do you recommend a jail sentence with credit for 105 days? He complete the MRT program and pay the restitution and follow the, assuming he gets convicted on something in the circuit court.
Correct.
Their probationary terms?
That is correct, Your Honor.
Ms. Mueller, what would you like to say about that recommendation?
I have no objection to it. I just would want to confirm Mr. Hayes understood that. Mr. Hayes, do you understand what the sentence would be on this matter?
Yeah, but I did our payment though. I made two payments. Already to her.
We originally were going back and forth about whether or not, and if there was documentation that Mr. Hayes said he had already paid $250 of that total amount, but we didn't get that far with that.
I did to Ms. Mulder.
Yeah. I will get that and can forward it. I believe he has sent me proof of the initial payments he had made, which we had discussed that those need to be made to the court. I think those have been made to Ms. Campbell.
All right, thank you. All right, anything else you want to say on behalf of your client?
No, not at this time, Your Honor. Or no, just no.
All right, anything you want to, did I ask you anything yet, Ms. McDuffie? I don't think so. I think I went to Ms. Johnson first, Ms. McDuffie.
I have the statement pulled up to read, Your Honor.
Okay, thank you.
So we got the statement from Ms. Campbell, and one moment, I guess in terms of context, it's probably important to recall that this was provided to us immediately after his plea was entered on the underlying case that he's violated on. So the new offense with those threats and things obviously happened after this. But she said that she had been on vacation for 3 days. I came back to my tires being slashed and threatening text messages that he sent out to people that used to be my friends, saying that he had intent on slashing my tires. What life was like after this was very difficult to get transportation for my children to get them to and from school. And the need to get groceries was made a lot more difficult. Financially, it drained my savings completely after having to get new tires. Psychologically, made me fearful for my life. Since he was able to do such crimes, he's shown how unstable he is in these past couple of months. I am constantly worried about my car nonstop, and if there is more damage that I'm not able to physically see. I've been experiencing an increased amount of panic attacks and anxiety due to worrying for my children's safety and my own. John Tavis Hayes has gotten worse mentally. He wouldn't leave me alone, constantly calling me on private setting and continued to threaten me and my children. A proper sentencing for John Tavis Hayes would be jail time and time in a psychiatric ward. I believe he is unstable and will continue to keep acting out without getting the help that he needs. I believe the psychological help will help him very much and start him on a better path to becoming a better citizen to society. Also, I want no contact in any way with John Tavis in any shape or form. And again, this is obviously before the new case.
Thank you. So the recommendation is for 105 days. I'm not necessarily saying I'm going to do that. So is there anything you want to say before sentencing?
And I don't know how the circuit court case will resolve, but I think there'll likely be lots of recommendations based on that. So I would be asking for on this matter, the credit for the time served, plus the recommendations from Ms. Johnson for MRT restitution.
All right, thank you. Oh, I think my computer just went down.
And I'm
All right.
sending, oh, sorry, Your Honor. I was just going to say, I'm sending the restitution information right now of the receipts for what's been paid so far. It looks like $250 has been paid so far for restitution.
All right, thank you. Mr. Hayes, anything else you'd like to say today, sir?
No, I'm good.
Well, this is what I'm gonna do. 365 days in the Washington County Jail, credit for 105 days served. The defendant is complete the MRT program. Once that is completed, he may be released. He is to pay restitution in the amount of $1,129. Credit for any payments that have been made. We have proof of $250 at this time. Defendant is on non-reporting probation. To track any probation that he receives. And what's the case number?
Your Honor, it is 24-685 FC.
That probation is going to be for 24 months. Fines and costs are waived. I'm going to do a review in this case on November 25th, 2024 at 10 a.m. to see how he's doing. I'll see you back here then to see if you completed the MRT program or where you are with that program, okay?
Okay.
Thank you.
No.
I'm okay, how are you? Good. All right. Excuse me, I did receive and review a letter that I received today from Sacred.
Do you want to stay here or hop over to Judge Braley? She's also live.
Heart. She's scheduled for intake on August 30th.
Yes, that's correct, Your Honor.
Did probation have a chance to see this as well?
I'm looking at it now, Your Honor. I just received it a little while ago.
All right, thank you. It looks like what
Okay.
We'll need 12. Okay, can you hear? We're good. Cool.
I don't know. Does he have all the economics?
They should be.
Oh, no.
Okay. B District Court is now in session. This is Magistrate Hillary Braley presiding. Now calling case number 23S00408. This is the State of Michigan versus Darius Prince. Can I have appearances for the record, please?
Assistant Public Defender Sonia Chenault on behalf of Mr. Prince. Sir, state your full name for the record.
Yes, Darius Prince.
Thank you.
Thank you. So today is the date and time set for an arraignment in this matter. What I am seeing is that a bench warrant issued on August 13th of 2024, and that was for a violation of probation. What I am seeing is a community corrections violation. There were a number of dates where you did not test as you were scheduled to test, allegedly.
No.
Okay, so
I'm sorry.
Attorney Chenault.
Thank you, Your Honor. We stand muted to the charges regarding bond. My client is 68 years old. He's gainfully employed at BizTech Corporation. My client explained, Your Honor, that he turned himself in last week on Friday for the violation. He did explain that he used mouthwash that contained alcohol on August 10th. He also expressed that he has not drunken any alcohol since July. I don't see any other active cases, so we are asking for a personal bond or a low cash bond in the alternative, as my client expressed he needs to keep his job, Your Honor. Thank you.
Okay, thank you. At this time, the court will set the date and time for the violation of probation hearing. That will be August 27th, so tomorrow at 10 a.m. And per the judge's order, bond is being denied at this time.
Thank you, Your Honor.
Thank you. But again, that next hearing will be tomorrow at 10 in the morning.
Thank you. And Your Honor, you said that's a bond violation hearing, correct?
Violation of probation.
Thank you.
Yes. Okay. Okay. Thank you.
I don't have the right to say anything.
Not about the case, Mr. Prince, but you will see the judge tomorrow, Judge Washington, at 10 o'clock, and then your bond can be addressed then again, okay?
May I speak with you?
Me, your attorney, or you're referring to the magistrate?
You as my attorney?
Well, not right now, because we're in the middle of the docket.
Okay. Because check my records. I have not had anything to drink. But okay.
I understand, sir. I do. I really do, as we spoke about it during the interview. But you'll be able to speak to an attorney again tomorrow before 10 o'clock, before you see the judge, okay?
Will it be you or another one?
It should be another attorney.
Okay. Thank you.
You're welcome.
Oh, okay. Can you hear me?
Okay, good afternoon. Can I have your name, please?
Aaron Hill.
I wanted to mention, remember when we were watching Judge Simpson last week, I said that I had someone in my calendar down as Atkins, and I couldn't remember why I had written Atkins down. So over the weekend, I checked my notes, and it's because it's the woman. So I posted a thumbnail of a woman in a Judge Simpson saying something about her being a mom. Turns out I have been looking for her details for a long time because I've got lady who was ill in brackets Atkins, May 3rd test, May 6th misses, May 15th misses, 17th in court question mark, 23rd negative, June 12th mental health court, had to use a walker August 22nd 9 a.m. So I'm just busy tracking down how many of those I have, and then I'll put it all together and we can watch her whole thing. And Styron, the subset, will either be in Judge Simpson's court tomorrow or Judge Washington's court tomorrow. But when I made the note, I didn't make it very well. So I'm a little bit stuck on that.
Now calling case number 24S00304. That is the State of Michigan versus Aaron Heald. Also calling 23W003567A and B. Also calling 23W002594A and B. Those are all the Township of Ypsilanti versus Aaron Heald. Can I have appearances for the record, please?
Assistant Public Defender Sonia Chanel on behalf of Mr. Hill. Sir, state your full name for the record.
Aaron Michael Hill.
Okay, thank you. So, before we address the new matter, just to get the township tickets out of the way, today's the date and time set for an arraignment in the ticket ending in 594A and the ticket ending in 567B. What I am seeing is that bench warrants issued in those back on October 26th of 2023. And it looks like that was for failure to appear for a pretrial. So, Attorney Chanel, did you want to address bond in those really quickly?
Yes, Your Honor. My client did explain regarding those two matters that he never received notice regarding those court hearings for those two charges. And we are asking for a personal bond in those matters. Thank you.
And actually, it looks like in the matter ending in 567B, he was never actually arraigned on that at all. So that was a citation from September 1st of 2023 that charges that on or about that date, he did operate a motor vehicle on Holmes Road at or near Wendell Street while your license was suspended, revoked, or denied. You understand that? Okay. I need you to speak up when you...
I do.
Okay, thank you. So that is a misdemeanor with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both. You understand that?
Yes, I do.
Okay.
Now for this matter ending in 304. What I have here is a misdemeanor complaint that charges that on or about August 24th of 2024. At 1236 Holmes Road, apartment 1. You did make an assault or an assault and battery upon Kristen Moose, a resident or former resident of your household and or an individual with whom you have or had a dating relationship. This is otherwise known as domestic violence. Do you understand that charge?
I do.
That is a misdemeanor with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both. Do you understand that?
I do.
Count 2 charges that you did through unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person. This is otherwise known as interfering with crime report. Do you understand that charge against you?
Yeah.
That is also a misdemeanor. It has a maximum penalty of up to 1 year in jail, a $1,000 fine with court costs, or both. You understand that?
I do.
Okay. And did you have a chance to review an advice of rights form?
No, nobody showed me anything.
Okay. So you have the right to remain silent. Anything that you say, whether out loud or in writing, can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury, and you have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. Do you understand all that?
And
So, Attorney Chenault, do you wish to address the plea and the bond?
Yes, we asked the court to enter a non-guilty plea standing mute. My client is 42 years old. He is unemployed, but he is seeking work at this time. My client explained that he is expected to start an outpatient program at Home of New Vision for alcohol treatment and therapy on this Wednesday. I did explain the bond conditions to him and how not to have any contact with the alleged victim. There are no other open cases nor holds. So, Your Honor, we're asking for a personal bond. Thank you.
Okay. Thank you. The next court date in all of these matters is going to be September 30th, 2024. That will be at 9 in the morning over Zoom before Judge Washington.
that's for all 3 cases,
That's for,
everything.
yes, everything, because you've got, it's 4 tickets. 2 of them are civil infractions and 2 of them were misdemeanors. So
Okay.
everything will be September 30th. And again, that will be at 9 a.m. over Zoom before Judge Washington.
Okay, so I have one question. Will I receive a link or whatever as far as like a meeting room for the Zoom?
So long as your phone number with the court is up to date, then it looks like you're enrolled in text message reminders. So you should get those.
I have a brand new phone number and I told my public defender that, and they told me as soon as I was able to call their office and update my number. So are they able to give that to you or?
Okay. Attorney Chenault, I'm just seeing NA here for phone number on the CAA form. So if you've got the new number, if you want to give it to me, that's fine. Not over YouTube.
Right. Okay, I will do.
Okay. Thank you. Okay. So now the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. Within 24 hours of your release, you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID. I would also suggest discussing with them that you're going to be potentially going to inpatient treatment and getting whatever release of information needs to happen there. Okay, because if you're going to be going into inpatient treatment and testing there, then they should be able to figure that out. Okay.
Okay. Is that back here at Hogback where I come to for the testing?
Yeah.
4 hours? Okay.
Yes. You are not to purchase or possess any firearms, ammunition, or other dangerous weapons. Any that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Kristen Moose. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the phone via phone calls, text messages, emails, social media, the internet in any way, shape, or form, or through third parties. You are not to go to the Holmes Road address. When the court tells you not to go, the court does not care if you own the place, rent the place, or are personally invited to return to the place. You do not go. If you have anything that you absolutely must pick up from there, you may do so on a civil standby. If that hasn't been explained to you yet, the public defender can do that later. You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behavior towards Kristen Moose or anyone else. You are not to engage in any sort of criminal activity whatsoever. And you are to appear for any and all dates set for you by the court. The next one in these matters being that September 30th court date at 9 a.m. over Zoom before Judge Washington. And I should note, you said you have a new phone. If for some reason you're not able to access Zoom with your phone, there is a tablet here at the Fort Indy District Court. Now, these conditions are going to be entered into the Law Enforcement Information Network, so they will be readily accessible to any police officers you may come into contact with. And if they should have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot and you'll be held for a bond violation hearing in front of the judge, who may revoke your bond and set a new, more restrictive one. So, do you have any questions about any of those bond conditions?
No, I don't.
Okay, you understand all of them.
Yes, I do.
Okay, so what the court is going to do in this matter ending in 304 is set a $10,000 10% bond. And if you are to start inpatient treatment, you may be released to inpatient treatment on a personal recognizance bond. Okay.
I'm doing inpatient treatment. This one that I had set up was outpatient.
Okay. So then the bond is going to be $10,000, 10%. If you're going into inpatient treatment, then it'll convert to a PR. But if it's outpatient, then you said it's.
I have no money. So, and I have no phone numbers to try to contact any of my family.
Okay, then, okay. Do you have any sort of documentation that Home of New Vision, the outpatient treatment starting on Wednesday?
I do, but my appointment card's at my residence on Holmes Road. I mean, you could call them. That's the only thing I can tell you to do. It's scheduled for 1 p.m. It's on Professional Drive just off of Washington.
Give me just a moment. Okay. So what the court is going to do is this. Because I was under the mistaken impression that you were starting inpatient. So given that it is going to be outpatient, given that there is not much of a prior criminal history here. Okay. The court will set a personal recognizance bond in this matter. It's going to be a $10,000 personal recognizance bond. So if you fail to appear for that September 30th court date, or if you violate any bond conditions, then your bond will start at $10,000 at that. Okay. But for now, you're being released on a personal recognizance bond. You are to provide proof that you are starting this outpatient treatment with Home of New Vision as soon as possible.
Right.
And as well, here, just a second, as I previously stated, I understand that the confirmation of all that is at your property, so you're going to have to wait for the civil standby before you go to the house to collect anything, and you're going to have to stay someplace else. Okay. Attorney Chanel, do you need me to clarify anything?
No, Your Honor, I understood everything. Thank you.
Okay, so you're still going to community corrections within 24 hours of your release. Okay, I believe they're open until 4:30. So, you're going to provide the proof that you're starting Home of New Vision on Wednesday. So if you go to the 14B District Court website, there's the email address for the Traffic Criminal Division. You can also provide it to your public defender and she can send it to us. You can bring it in, however you want to get it to us. Okay.
Okay. So I bring it to that 24-hour checkup they'll have. Okay.
So I'm sorry, say that again.
So you say bring the proof in for the new Home and New Vision, like to that 24-hour check-in that I'll be doing?
So the court's going to need it too, so you should probably just give it to your public defender and she can make sure that we get it. But you may want to take it to community corrections as well.
Okay, I'll have it with me.
Okay. So, Attorney Chenault, was there anything else?
I just wanted to state, Mr. Hill, once you learn your new telephone number, can you contact 14B Court and update that so you can get reminders on your upcoming court hearing dates?
Yes. Do you want me to do that through the public defender's office?
Yes.
Yes, and use your name?
Yes, you can.
Okay. So,
Thank you.
All right, thank you.
Okay, thank you. Then if you actually, and just to be clear, as far as the two misdemeanor driving while license suspended tickets, the court's just setting a personal recognizance bond in those two matters.
Thank you, Your Honor.
Thank you.
Thank you. Okay, so if you don't have any questions for the court at this time, you are free to go to the door and tell the jail that you are finished.
I don't. Thank you very much, Your Honor.
Okay, thank you.
I can't hear you.
Nope, it was me. I was muted.
Okay.
Sorry about that. Okay, can I have your name, please?
Donald Brown.
Okay, thank you. Give me just a moment. This is the state of Michigan versus Donald Lewis Graham II. Can I have appearances for the record, please?
Assistant Public Defender on behalf of Mr. Graham. Sir, state your full name for the record.
Donald Lewis Graham, second.
Okay, thank you. Today is the date and time set for an arraignment in this matter. What I have here is a misdemeanor complaint that charges that on or about August 24th of 2024 at 7257 Wellington, you did make an assault or an assault and battery upon Donald Graham Sr. Do you understand that charge against you?
Yes, Your Honor.
Okay, thank you. That is a misdemeanor with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both. Do you understand that?
Yes, Your Honor.
Okay, thank you. You do have the right to remain silent. Anything that you say, whether out loud or in writing, can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury, and you have the right to be represented by an attorney during all stages of these court proceedings. So, do you have any questions about your rights?
No, Your Honor.
Okay, thank you. Attorney Chenault, do you want to address the plea and the bond?
Yes, thank you, Your Honor. We ask the court to enter a non-guilty plea standing muted to the charges. My client is 42 years old. He currently receives a veteran's pay as his source of income. Your Honor, I did explain his bond conditions to him and how not to have any contact with the alleged victim in this case. I do believe he will be in compliance going forward and appear for all subsequent court hearings. There are no active holds on his record, no other cases, so we are asking for a personal recognizance bond. Thank you.
A pretrial conference date of September 30th, 2024. That will be at 9 in the morning over Zoom before Judge Washington. And the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to purchase or possess any firearms, ammunition, or other dangerous weapons. Any that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Donald Graham Sr. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the phone via phone calls, text messages, emails, social media, the internet in any way, shape, or form, or through third parties. You are not to go to the Wellington Lane address. When the court tells you not to go, the court does not care if you own the place, rent the place, or are personally invited to return to the place. You do not go. If you have things that you absolutely must pick up from there, you may do so on a civil standby. If that hasn't been explained to you yet, the public defender's office can do that. Okay. You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behaviors towards Donald Graham or anyone else. You are not to engage in any sort of criminal activity whatsoever. And you are to appear for any and all dates set for you by the court, the next one in this matter being that September 30th court date at 9 a.m. over Zoom. Do you understand all of those conditions?
Yes, Your Honor.
Okay. Do you have any questions about any of them?
No, Your Honor.
Okay. Thank you. The conditions will be entered into the Law Enforcement Information Network, so they will be readily accessible to any police officers you may come into contact with. And if they have probable cause to believe that you have violated one of those conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one. Do you understand all that?
Yes.
Okay. Thank you. So, at this time, the court is going to set a $5,000 personal recognizance bond. So what that means is you're not paying anything to get out. You are promising to appear for your next court date. But if you fail to appear or if you violate any bond conditions, then your bond will start at $5,000.
Okay.
Okay. Attorney Chanel, anything else?
No, nothing further. Thank you.
Okay, thank you. Then, sir, if you don't have any questions about anything the court just said, you are free to go to the door and tell the jail that you are finished. Your hearing is concluded.
Okay.
Okay, thank you. Good afternoon. Can I have your name, please?
Good afternoon, Your Honor. Lance Thompson.
Okay. Moment, please. Give us just a moment, please.
You're fine.
Matter what I am seeing.
Public Defender Sonia Chanel on behalf of Mr. Thompson. Sir, state your full name for the record.
Lance Channing Thompson.
Thank you.
So today is the date and time set for an arraignment in this matter. What I am seeing is that a bench warrant issued back on December 20th of 2022, and that was for failure to appear and failure to pay. So it looks like this was initially, it's a DV case, but it looks like you just have a balance remaining at this point. So you were set for a show cause hearing back then.
Yes, Your Honor.
Okay. Thank you. So, Attorney Chanel, did you want to address the plea in the bond?
Yes, Your Honor. Thank you so much. We stand muted to the charges regarding bond. My client did explain that around that time, he was in the process of having a baby with his fiance, and as a result, he did miss that court date. So, but we would just be asking for a personal bond. Thank you.
Okay. Thank you. And Attorney Chanel, how did your client come to be in custody today?
Well, my client did inform me that he was locked up since last year, November. He was released on Friday. He was transported to Wayne County. And then he came to Washtenaw County, I want to say this past weekend.
Okay.
And also, I turned myself in on those charges. I knew what I had going on, so I knew the possibilities of Wayne coming to pick me up and me coming here. So I knew that.
Because I'm seeing, yeah, what you were on probation out of the 18th district.
Yes, ma'am.
And then there's bench out of the 34th and the 20th and the 29th.
Yes, Your Honor. If I may, what happened with those is I was on probation for those counties too, and I was just struggling trying to.
Okay, well.
So I'm gonna, you don't have to talk about.
Okay, I'm
just,
sorry.
You know, no, that's fine, but it just, probably don't want to do that on the record. So
Right.
as far as this case goes, you have a balance due of $1,718.
Okay.
Do you anticipate getting out soon?
Yes. I mean, I don't see me really being locked up too long. Yeah.
So what I am going to do is set a show cause hearing date. That is going to be December 17th. Okay.
Okay.
So December 17th, 9 a.m. That'll be over Zoom in front of me.
Okay.
Hopefully by that point you will have been released. Assuming that that is the case, I do want to see some sort of good faith effort made to pay on this.
I will, Your Honor.
Okay. Thank you. So we'll have a date to check in December and see where you're at. Okay.
Okay.
Okay. Do you have any questions?
Does that mean I will be is that a personal recognizance bond or?
Yeah, so with this case, yes, it'll be a personal recognizance bond. You're just at the point where you owe money. We're not going to set anything. So
Okay.
yes, personal recognizance bond in this matter. Okay.
All right. Thank you, Your Honor.
Okay.
Thank you.
Thank you.
Thank you.
You're welcome.
Good afternoon. Can I have your name, please?
Tanisha called Greenberry.
Okay. Thank you. Give me just a moment.
Okay.
Calling case number 22T00843. This is Ypsilanti Township versus Tanisha Cole Greenberry. Can I have appearances for the record, please?
Assistant Public Defender Sonia Shanat on behalf of Ms. Cole Greenberry. Ma'am, state your full name for the record.
Tanisha called Greenberry.
Thank you.
Thank you. So today is the date and time set for an arraignment in this matter. What I have is a misdemeanor complaint that charges that on or about January 1st of 2022 at 2127 Gulfside, you did operate a vehicle in a place open to the general public or generally accessible to motor vehicles while under the influence of alcohol and or having an alcohol content of 0.17 grams or more per 210 liters of breath or per 100 milliliters of blood. This is otherwise known as operating while intoxicated with a BAC of 0.17 or more. Do you understand that charge against you?
Yes.
Okay. That again is a misdemeanor with a maximum penalty of up to 180 days in jail, a fine of not less than $200 or more than $700 plus court costs or both the jail time and the fine. Do you understand all that?
Yes.
Okay. You do have the right to remain silent. Anything that you say can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury, and you have the right to be represented by an attorney during all stages of these court proceedings, that is, before, during, and after trial. So, do you have any questions about your rights?
No.
Okay. Attorney Chenault, do you wish to address the plea and the bond?
Yes, thank you. We stand muted to the charges and regarding bond. My client is 30 years old. She's gainfully employed as a direct care worker. She is also a mother to a 10-year-old child whom she cares for solely. Your Honor, I did explain her bond conditions. I believe she will be in compliance going forward. There are no other open cases, so we are asking for a personal recognizance bond. Thank you.
Okay, thank you. I'm seeing a couple bench warrants for failure to appear out of the 35th district.
Is that Canton?
Yes.
Yes.
Okay. So at this time, the court will set the date and time for a pretrial conference that will be October 2nd, 2024. That will be at 9 in the morning over Zoom before Judge Washington. And the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. Within 24 hours of your release, you are to report to community corrections for drug and alcohol testing.
Okay.
You'll need $12 and a photo ID. You are not to leave the state of Michigan without the court's permission. You are not to engage in any sort of criminal activity whatsoever.
Okay.
And you are to appear for any and all dates set for you by the court. The next one in this matter being October 2nd at 9 a.m. over Zoom. That also means going to community corrections within 24 hours of your release.
Okay.
Do you have any questions about any of those conditions?
Is the community corrections is the one that's right around the corner right here? Or is it down?
Yes, it's basically straight up the hill from where you are right now.
Okay.
It's in the same campus as the jail and the court. The building's labeled re-entry center.
Okay.
Okay. These conditions will be entered into the law enforcement information network, so they will be readily accessible to any police officers you may come into contact with. And if they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot and you'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one.
Okay.
Okay, you understand all that as well?
Yes.
Okay. Do you have any questions about anything that I just said?
No.
Okay. So at this time, the court will set a $5,000 personal recognizance bond. So what that means is you're not paying anything to get out. You're basically promising to appear for your next court date. But if you fail to appear or if you violate any bond conditions, then your bond will start at $5,000.
Okay.
Okay. Attorney Chenault, do you have anything else?
No, nothing further. Thank you.
Okay. Thank you. Then, ma'am, if you don't have any questions, you are free to go to the door and tell the jail that you are finished. Your hearing is concluded.
Thank you so much.
Thank you.
Para at that time at the Rose Hill Mill
Reflect that in second.
for sentencing. Jen, if you get that appointment to Mr. I will maintain No contact to continue.
Thank you. You have a nice day.
You too. Mr. Patterson, who do you want to take up?
Judge, we have one left at court security, if we can take that one up, and that is Miss Reed, REID.
We're on the record in 2023 TR 1443, State of Kansas versus,
Judge, I was told it's Taysonet. Is that right?
Dejanay.
Dejanay Marlise Reed. Please announce appearances.
State appears by Devin Canfield.
Your Honor, Darren Patterson, appear on behalf of Taysonet Reed, who does appear from Courthouse Security One video station. Judge, after talking with Miss Reed, this is my first opportunity to talk with her. It does appear that she has valuable information that she needs to get to me. Would ask court to allow me several one additional time to resolve the case.
State's response, if any?
No objection, Your Honor.
Okay, that will be granted to November 18th. Ms. Reed, be back here at 8 a.m. and I don't know what happened, but you had a September 13th, 23 failure to appear and a February 21st, 24 failure to appear. So make sure that you get that date where you won't forget it, okay?
Yes, ma'am.
All right, nothing further. I'll continue the bond with the added condition that you stay in touch with Mr. Patterson and reappear on that November 18th date.
Okay.
Thank you.
Thank you.
You may go. Deputy, is that everyone? Must be, or he'd be letting me know. Deputy Caulfield, was that your last one?
That's the last one I have here, yes.
Very good. How about Kayla Wallace?
Yes, Your Honor.
Okay, she must have been at it since Friday. Or whenever I printed this. We're on the record in 2024 CR 310, State of Kansas versus Kayla Renee Wallace. Please announce appearances.
Jared Regier on behalf of the state.
Okay, I see Miss Wallace appears in person. Miss Wallace, you're here on domestic battery.
Yes, Your Honor.
First appearance was July 3rd.
Mhm.
You're going to hire counsel. Where's your counsel?
That ideally was the plan, and I just wasn't able to get the money together for it.
So what is your plan now?
I put in an application for a court appointed,
All right, when did you do that?
just last week at the very last minute. I'm
Yeah.
sorry, Your Honor.
Okay. So where do you work?
I work at Dillon's and Andover.
Sorry to interrupt, but there's a small claims trial live. Oh man. Of course. I didn't want to miss it. Also, I just realized you're looking at the lava lamp, not me. I need to go have some dinner soon. I was just trying to find Atkins' first appearance, and then I got a notification about the small claims trials. So Atkins is the woman I was talking about earlier. I don't have May 3rd. I only started around May 20th from what I can see. I could be wrong. I could be not looking properly. But we have movement. I have a massive update. I can't believe I forgot to tell you guys this. I've had it in my court to watch thing for the longest time. Dee Warner's remains may have been found on the property. Once I get the full hearing, if they do a full hearing, we will watch it. But
That's correct.
yeah, little bit bittersweet for the family, but now they at least have something, you know, like they basically what happened was they realized at some stage that something clicked about what the police were looking into and things the husband had said, and it was in a fertilizer tank. Okay, so my first live was 20 April. So maybe I watched Judge Simpson. I just don't want to like go through all the information just yet because there's a lot that's unconfirmed and there's a lot that you know how I am by now. Like I want to hear the full story before I put anything out there that hasn't been fact checked. Here's a spontaneous live. What day did I do this? 1st of May. Okay. Oh, the microwave's going to beep. That's because Vaughn is amazing and is making dinner. And there's Frank just adding for the sake of it. Okay. So if that is April, now I'm checking my streams to see maybe I was in Edinburgh. And then we have the mold one. That was May. That was May for sure. May 12th. And at that point, May 16. What day did I say I need? 17. Damn. At that point, I was watching a lot more landlord tenant, so I don't anticipate there being criminal, which is what we need. We need criminal hearings. Oh, but you know what as well? I used to actually catch up on Judge Simpson in retrospect. So we might get lucky. Let's see. Okay, small trial. Can we please have a little bit of a start here because I'm hungry and I'm way nervous to walk away. That's a landlord tenant. That's still landlord tenant and still. Not pizza, not pizza. We're having stew, which I don't think you guys call it stew. It's like curry without curry. I literally just watched Landlord Tenant. That is what I watched.
Good afternoon. We are convened on the Butler County Small Claims docket. I have 2 cases on the docket today. Ms. Baylin, is there anyone else that's not yet admitted to the meeting that's calling in?
No, sir.
All right. The first case I'd like to take up is Home Bank and Trust Company versus Christopher Wilbur and Kara Wilbur. The case number is Butler County 24 SC 033. Are you appearing for Home Bank, Mr. Rucker?
Yes, I am.
All right. Home Bank appears by Mr. Rucker. There are no other appearances. This matter comes on a petition seeking $4,000. Mr. Rucker, is there anything else you'd like to add or any motion you'd like to make at this time?
No, there's nothing else I'd like to add other than what I've presented.
Okay. Well, based upon the Wilbur's non-appearance here today, I will rule in favor of Home Bank in the amount of $4,000 by default. And if you could please, Mr. Rucker, prepare the appropriate order for my review, I would be in your debt.
Yes, I sure will.
All right. Thank you very much. And if there's nothing further, we're adjourned on the Home Bank versus Wilbur matter. And you are free to log out of the meeting, Mr. Rucker.
Okay, thank you very much.
Thank you.
Yeah, pretty much.
Right. The next case that I have is Dixie Kuhn versus Wendy Goldsmith. The case number is 24 SC 034. If you could, each of you please unmute and come into the meeting, I would appreciate it.
There it is.
Ms. Kuhn, can you see and hear me okay, ma'am?
Yes, I can.
And Ms. Goldsmith, can you likewise see and hear me okay?
Yes, sir, I can.
All right. We're here on the petition of Ms. Kuhn seeking damages from what she has alleged to have been a parking lot contact with her vehicle. This would only be reasonable if each of you would wish to do this. But before we get started, do you, Ms. Kuhn, have any desire to go into a breakout room and speak with Ms. Goldsmith?
Well, I have tried to reach out to her numerous times, but she doesn't return my calls and or emails.
Okay. Well, she is here now, and I don't want you to feel any pressure to do this, but if you would think there would be any value in speaking with her before we actually convene a trial, I'm happy to inquire of Ms. Goldsmith if she likewise would like to do that. And if both of you do, I can put you into a breakout room where you could speak privately and see if any common ground is to be found.
Sir, I think I'd prefer that you settle this dispute for us. I'd feel the most comfortable in that setting.
Okay,
So,
well, and like I said, that would have to be both parties wishing to do that, so we can call this case for a trial, then the way this will work mechanically is each of you will be given a chance to make an opening statement, basically saying what you think the evidence will be at trial. If each of you intends only to testify yourselves, I'll swear both of you in. I'll give first Miss Kuhn an opportunity to tell her side of the story. You could follow that up, Miss Goldsmith, with any questions you might have for her. If there's no other evidence after Miss Kuhn has finished, you, Miss Goldsmith, will be given a chance to tell your side of the story, and then Miss Kuhn will have an opportunity to ask you questions. Once each of you have rested your cases, each will have an opportunity to make a closing statement, which is basically your prayer as to how the court would consider the evidence that has come in. And from there, I'll make a judgment on the case. And depending on what findings I make, there will be potentially other matters to take up after that. With all of those things said, I'll inquire of you first, Ms. Kuhn. Is there anything you'd like to say by way of an opening statement?
I have, you've read my statement.
Mhm.
And that's basically what happened, but I do have pictures.
Okay, and I think you had submitted a document for the court that had a bid and some pictures. Is that what you're talking about?
No, I'm
Okay.
talking about pictures of the actual, her pickup truck in my lane.
Okay.
Um,
Well,
bid.
and we can get to those in your case, in chief, in your testimony. But was there
Okay.
any overarching statement you wanted to make about what you think the evidence will show after you've presented your side of the story?
Well, I believe the evidence will show that she was so far over into my lane when she opened up her rear pickup door that it did damage my car, and it was so loud that I turned around to see if something exploded in my car because it was so loud. And as I turned around and walked back, because she wasn't there when I walked toward the dentist office. So she was there when I heard the explosion, and her car door was still touching the rear panel of my car. And so I said, I'm going to move my car before any more damage is done to it. So that's when I got into my car and moved it to the parking stall behind us. And then that's when she said, well, I'll make it right. And then I asked for her name and phone number, thinking that we could settle this, without me having to do this.
Okay. All right. Ms. Goldsmith, do you have anything you'd like to say by way of an opening statement, what you think the evidence will show?
I believe the evidence will show that although I was parked across the line, as Ms. Kuhn mentioned, that there isn't any way that my car did the damage that she believes occurred. I also do have some photographs that were taken by my insurance company. I recorded what I believe, she mentioned the loud sound, and I have a recording of the sound that the truck does make when doors are simply opened. And I can share that with the court today. But I guess finally, I would say that I believe I have evidence that shows that my vehicle did not do the damage to her car that she believes. So.
All right, thank you. Well, if you want to testify, Ms. Kuhn, I will swear you in. If you could please raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give in the cause now and hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead, and you can tell me in fuller detail. I got a little flavor of what had happened, and I have read your petition, but if you'd like to tell me more specifically what happened and what your concerns were, if you want to show those pictures you mentioned you brought with you, you may do that. And certainly if you want to speak to the submitted bid, you're welcome to do that as well.
Okay. On the 22nd, I had an appointment at the Andover Family Dentistry, and I parked at the in lane because I didn't want anybody banging my car like people do. And so there wasn't anybody parked on where she was parked. So I walked in toward the dentist office, and then I heard this loud bang, and I thought maybe something exploded in my car. So I turned around, and her truck was there, and her car door was still attached to my car. And I said, "You hit my car." And she said, "I did." And I said, "It's right there. It's still attached." And she said, "Well, I'll make it right." And so I said, "Well, I'm going to move my car so it doesn't have any more damage to it." And then she said, "Well, I'll make it right." And I said, "Well, give me your name and your phone number." If she didn't do that, I don't randomly just ask random people for phone numbers and their name. So I got her phone number and her name, and I went in and took care of my business. And when I came out, I decided I would take pictures showing how far over into my lane. I took her driver's license. That's her driver's license. I mean, her tag. This is how far over she
And
was.
if you'll just hold that there steadily for a moment, I'm sorry, but this screen isn't particularly crisp, and I'm going to use a magnifying glass to really see the detail on this. Okay, thank you.
This was another angle. Can you see?
I can, yes, ma'am.
And then, do you see her rear vehicle, how far over it was into my lane?
Yes, ma'am, I can see that.
So, I thought she would take care of it. So that's when I got an estimate on the 22nd, the same day. So I just went from the dentist office to Lexus, and he said, take it to CarStar. And he said, that's where we take the Lexus to get fixed. So that's when I got an estimate to fix the car. And then I tried to call her and no answer. I tried twice. I emailed her the pictures. I emailed her the estimate, and she didn't respond. So I had no other recourse than I contacted my insurance agent, and he said, you would be best to take her to small claims court to try to get her to pay for your car. So that's how I ended up doing this.
All right. If you have nothing further, I'll ask you, Ms. Goldsmith, do you have any questions for Ms. Kuhn?
Yeah, I do have a question or maybe a clarification, because we had only communicated our phone numbers to each other. Ms. Kuhn did share the estimate with me and the pictures as well, but it didn't come through an email. We've only communicated through our phone numbers. I just wanted to clarify. And also, sir, I did receive the messages from Ms. Kuhn, and I also spoke with my insurance company. And they advised me that because there was no police report, there was no official documentation of what had occurred, that I was not legally obligated to respond, because as I thought through what I believe happened, I'm still not certain that it was my vehicle that did the damage. And so that's why I chose not to reply to her, because I wasn't ready to take any more steps if I was not legally responsible. I'm sorry, that wasn't really a question for Ms. Keene, was it? I apologize. I guess I do have one other question for sure. You did mention a very loud sound. I have a video of the sound that the door makes when it opens. The truck has been in several other surely before we purchased it even. And so the front door, when it opens, it does make a creak. And so I have a video of that, if that evidence would help. And also, Ms. Keene, I wondered if maybe you heard the tailgate close, because I had gotten out of the vehicle and I honestly don't remember the steps of the process that day, but maybe I had taken my mother-in-law's walker out of the back of the truck and I had shut the tailgate, and that does make a rather loud sound. So I don't have a recording of that sound today, but I'm just wondering if possibly that is what you heard as opposed to the sound of my car door coming in contact with your car. Those are all the
All I
questions I have.
know is I have a dent in my car where your car door was attached to it when I walked over there.
I guess I'm disagreeing with the word attached. I understand that the door may have been touching your car, but when I hear the word attached, I understand that you would mean like it would take great force to pull it away from your car. And I don't recall that being an issue at all, ma'am. So.
It made a
Okay.
dent in my car.
Do you have any other questions for Ms. Kuhn, Ms. Goldsmith?
No, I don't. Thank you.
All right. And Ms. Kuhn, if you don't have any further evidence, I'll be poised to let Ms. Goldsmith tell the full of her side of the story. Ms. Goldsmith, could you please raise your right hand?
Oh, yes.
Do you solemnly swear or affirm that the testimony that you're about to give in the cause now and hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank
I
you.
swear.
If you can
Thank
go
you.
ahead and tell your side.
Sure. I'd like to actually read a statement. After the incident, I went home and just recorded my thoughts. And so I'm going to read this statement for you. I arrived at the Andover Family Dentistry at 10:50 a.m. for my mother-in-law's appointment at 11. I noticed there were not many parking spots left, so I chose a spot in front of the building between two cars, Miss Keene's car on the left and another car on the right. As I opened the truck door, I remember being extremely careful for my door to not touch Miss Keene's car. As I got out and began helping my mother-in-law get her walker from the truck bed, Miss Keene approached me and asked, "Did you just hit my car?" I spoke with her about it briefly and explained that I don't think I did because I had opened my door very carefully before getting out. She said that she heard a bang and thought that I had hit her car. She also said that she had purposely parked over to the left so that no one would hit her. She then moved her car across the parking lot and we spoke again about what might be done. I walked across the lot and I looked at her car. She pointed out a white scratch on the right rear tire fender flare, but I did not see a dent where the truck door may have hit it. We exchanged phone numbers and she asked if I was from Andover. I told her that I was from El Dorado and had brought my mother-in-law over for an appointment. She said that she may have someone look at it and then let me know. There were several times in our conversation that day, sir, that I did say, if this were my fault, I would like to make it right. And I know that was my full statement. I said, if this were my fault, I would truly like to make this right. Then I went into the office as well for my mother-in-law's appointment, and I was able to sit and process more clearly what may have happened. And so that's when I mentioned before that the truck doors do open with a popping sound, at least the driver's side door does open with a popping sound. So I wondered if maybe that she heard just the door itself opening, not necessarily coming into contact with her car. And then, yeah, I finished my statement here. I truly did not notice any dents, and I did see the white scratch that was mentioned before. But then when I looked at my truck later, there was no her Lexus is green, I believe, and there wasn't any paint on my truck that would have showed evidence for that. I do also have some pictures. I'm not sure if it would be appropriate to share my screen with you. I think I know how to do that through a Zoom meeting, or if you'd like to see paper
If
copies,
you'd like
I can do
to,
that as well.
as long as you're sharing it in a way that Ms. Kuhn can also see it, that would be
Oh,
fine.
sure. Of course. I may just show the photographs then, because that's probably best for me in the situation. Our insurance adjuster came on August 9th, because after I received the court summons, then I reached out to my insurance company again, and said, I do need some help with this situation. And so an adjuster came and took lots of pictures. To be honest, I'm not sure which ones are specifically the ones that you need. So let's see, there's just a lot of pictures here with like measurements. The adjuster, he measured like from the ground up to the ground up to the door itself and where the contact might have happened.
Okay.
Okay. And let's see, I'm not sure how many of these are specifically relevant. There's another one there.
Okay.
Okay. And then also I did.
Those pictures
sorry.
taken.
I'm sorry. What did you say, ma'am?
Where did they take those pictures?
Where were they taken? They were in a public parking lot in El Dorado. An adjuster came to take the photographs of my car shortly after the summons that I received from you. So.
Okay, because they asked if they could take pictures of my car, and I said yes, but I never had anybody come and take a picture, or I would have showed them where the dent was.
Oh, okay. Truthfully, I received a copy of those photos. I'm not sure why you didn't, Miss Keene, but my insurance company was able to get information from yours, and I do have it's a long letter, but I could read the statement that my insurance company shared, showing that they believe that the damage was not done by my vehicle. Would it be appropriate for me to read it out loud, sir, or what would be best?
Well, in as much as they're not here to be cross-examined, I think I would prefer it if you just sort of summarized your opinion and belief about any thing that you think may have happened, or some explanation that you think is appropriate as to why you don't believe that it was indeed your vehicle that could have caused the damage.
Okay, let's see. There are some very specific measurements here about with those photos that I showed, like 70.5 inches, and how high the door would have reached compared to the scratch and the dents that are on Ms. Keene's car. Oh, I actually do have the photographs. Yeah, this came to me from my insurance. This is Ms. Keene's car. I'm sorry, let me move it that way.
Yeah, I think actually the court has received
Oh,
these
did you?
photographs.
Oh, very good.
Yeah,
Okay.
and
Okay, thank you.
from the plaintiff. Thank you.
Sure. Okay. So to summarize the letter, yes, it talks about when they received the photographs. The front driver door of the Chevrolet has a straight edge with a slightly rounded shell and does not include any embellishments. It mentions that the distance from the ground to the bottom corner of the truck door would be lower than the dent that appeared on Mrs. Keene's car. The scratch that was shown, there are numbers connected with these photos, but the scratch appears to be less than an inch long and is angled. If impact occurred from the Chevrolet's door, it would have impacted the molding or flare first. Let's see, if the Chevrolet's door had impacted the molding or flare, the damage would be more than a singular scratch, as the door has a straight edge. And then truthfully, she did mention specifically about the rear door being the one that was touching her car. And there is a rubber, I'll call it a gasket, that protects that when that rear door opens. The rubber would make contact with someone else's vehicle first before any metal would or plastic would touch the car, which I also believe shows that even if my door were touching her car, that the damage, that she saw would not have come from that truck door because of the rubber gasket. I do have a photo of that that I could share if that would be helpful. Sure. Okay, let's see, I can get my, let's see, I think, oh, let's see, it was this photo right here. Okay, and then I need to take the steps to share it. Oh, let's see, share screen, okay. Okay, so there is our court, and then, so this is the door that she believed touched her vehicle, and as you can see, there's a rubber gasket that runs top to bottom, and so if the door did make contact with her car, it doesn't appear that the damage, that rubber gasket would have caused the damage that she's seeing.
That's the rear, you have a double cab.
Yes, yes.
And it was the rear door that banged against my car that hit my car.
Yes.
And I don't know if you have a rubber gasket or not, but it was hard enough to dent my car.
And that's, I'm expressing there that the rubber gasket is there. The photograph that's right there that should be in front of you does show the rear door and the rubber. I believe there's actually maybe 2 rubber pieces that would have contacted your car first. And again, to speak to the evidence of the sound that you heard, let me see if I can find, I have just a rather short.
And just so
I'm
I
sorry, go ahead,
understand,
sir.
do the front
Uh-huh.
and rear doors open in opposite directions? Am I understanding that correctly?
Yes, sir, they do. They open like this. Yes.
Okay.
If it's appropriate, I do have a very short video of the sound that I believe maybe
Sure,
Mrs.
that's
King
fine.
heard. Okay. Let's see. Oh, okay. That is not it. I apologize. It's in a different file here.
I couldn't hear it on my
Oh,
screen.
okay.
Is there a way
Um,
to adjust the volume?
Yeah, I can turn up mine as loud as possible.
Okay.
And maybe try that again. Let's see here. Okay.
Let me see if I can do anything because I'm not hearing it at all.
Okay. Okay.
Are you able to hear it, Miss Kuhn?
I do not.
Oh, okay. I'm not sure then how to share the audio, I guess, truthfully.
But basically what you're saying is there's been some damage to the door previously that when you open it in normal use, it has a sound associated with that prior damage, and the movement of the door kind of through or against that.
Yes, sir. That's what I would say. And also, as I said before, Ms. Keene said that she heard a loud sound, and I'm speculating, sir, that it was the sound of the tailgate, that I had lowered the tailgate. And then when I slam it shut to make sure it stays, that does make a rather loud sound. I don't have a way to share that sound with you right now, but to answer her question, I suppose, or the concern about that, I believe that's the sound that she may have heard was the tailgate itself or the door sound that I tried to share. So.
All right, thank you. All right, if you don't have anything further, Ms. Goldsmith, I'll inquire, Ms. Kuhn, do you have any questions for Ms. Goldsmith?
Well, I think I've heard enough tailgate slam that I can differentiate between a banging against another metal object or a tailgate. So it wasn't a tailgate that I heard.
Okay. Did you have any other questions for Ms. Goldsmith?
She saw that her car door was against mine, and the dent wasn't there when I pulled into the dentist office. So I don't understand how she can say she didn't do it. So I guess I'm kind of baffled by that.
Okay. Well, if you don't have any further questions, and if there's nothing further from either of you as far as any evidence, I'll inquire of you first. Ms. Kuhn, do you have anything you'd like to say by way of a closing statement? What you think the evidence has shown and what you think the court should do?
Well, I know that when my husband passed away and I went to sell his car, that there was a dent on that back end, and they deducted monies from the price of the car because it did have a dent. Even though this dent isn't very big, I know that when I go to sell the car, they will deduct monies from the sale of the car because it has a noticeable dent. And I would just like my vehicle to be in the same condition that it was before Miss Goldsmith's truck door hit my vehicle.
Okay.
So
Ms. Goldsmith, do you have anything you'd like to say, what you think the evidence has shown and what you think the court should rule?
I guess just to restate that I am aware that I was parked over the line. I am aware that my rear door touched Miss Keene's car, but I do not believe that I caused the damage that she saw there because of the rubber gasket that was on the door and the sounds that my old truck makes when we open and close things. And so I believe that the evidence would show that although there is damage to her car, this is true, that it was not my vehicle that caused it.
Okay. All right. Thank you both. I don't think this will take too long, but I want to go off the record just to review the file and just kind of think about what each of you have argued. And then I'll be back probably within 5 or 10 minutes at the outside, and I'll render a verdict at that time. Thank you.
Thank you.
All right, we are back on the record in Kuhn versus Goldsmith, Butler County 24 SC 034. I have had a chance to consider the evidence, and there are a handful of points I want to make. First of all, I think each of you have made your cases well. You've given the court quite a bit to think about. And I certainly, in response to one comment that was made, I do want to be sure and explain that even if something seems obvious to one party, it might not be the case that it's quite so obvious when the other side of the story is heard. And I think that both parties were well within the parameters of doing their respective arguments from a position of allowing the court to consider the points that were important for the court to consider. And I did not think anyone was overreaching or engaging in any sort of misdirection or anything of that nature. That said, I also want to compliment the parties just for the genteel nature of your interaction at the parking lot and even through to today. I mean, I recognize that there were a lot of moving parts along the way, and it had the potentiality to become less civil. And I appreciate the way that each of you have, again, tried to do your best to work this through to a conclusion without devolving into any ill will or anything of that nature. The court is confronted with a couple of data points that are pretty important. One, there are apparent potential other explanations for the noise, and there are explanations offered by Ms. Goldsmith as to the unlikelihood that it was her door that had caused the damage. And I think those are relevant. I also think it's important to note that even Ms. Goldsmith concedes that because of the busyness of the hour at the dentist's office when she and her mother-in-law had arrived, parking options were kind of few and not very enticing. But Ms. Goldsmith admits to having necessarily felt compelled to park over the line in those circumstances. And also that I think all the parties are in agreement that at some point at least, the rear door was touching Miss Kuhn's vehicle. And I guess the big question comes down to, what's the likelihood of that contact having done the damage that's been reported to the court, and the amount of damages that are being sought here. And I do have to say, just in context, the amount is for the apparent smallness of the damage done, seemingly a relatively high amount. But I do also understand that professional service providers, including body shop folks, have expertise, and there's a lot that goes into doing the jobs they seek to do. So I'm at once stunned and at the same time completely understanding as to the amount that they have indicated, $1,816 and change, if I remember correctly. And so I think the question becomes, for this court, where does the rubber gasket and more or less straight-edged nature of the rear door leave off, and where does the fact that the door was touching the vehicle owned by Ms. Kuhn pick up, as far as trying to ascribe fault to this situation or lack thereof? And I guess the court, in looking at the pictures that were submitted, and by the way, I appreciate each of you having done so. I think you helped your cases in so doing, but I also think that it gives the court some background from which I am going to do my best to make a fair decision in the case. I think that the rear door of the pickup in question, if viewed from the front or the back of the vehicle with the door closed, is at least a little bit convex. It sticks out. The body has a little bit of curvature, as most vehicles do, from the running board to the top of the door sill, at least, and usually on up to the roof line of the car. And honestly, I could see it having happened, that the trim damage was mitigated by the self-same rubber gasket that appears in the pictures, whilst the rubber having been pulled back along the line of the trim piece might have exposed metal at a convex and farther reaching portion of the door so as to render the dent that has been submitted into evidence and for which these damages are sought. And it gives me no joy to do this, because I think each of you are delightful and each of you have presented your case as well. But the court is convinced that it is the case that the damage was indeed done by Miss Goldsmith's truck door. And I am, in that context, trying to find for the plaintiff and the amount requested, $1,816.64. And Ms. Kuhn, if you could please prepare an order along those lines for submission ultimately to the court. And Ms. Goldsmith, I would appreciate it. And thank you both for appearing here today. I appreciate it.
Thank you.
And Ms. Bailyn, I think that's our last small claims case, and I'm going to go off camera and off mic, and I'll see you again at 2:30. Thank you.
Thank you.
Wait, can you actually hear me? Can you hear me now? Can you hear me now? I haven't added my things to the screen, so you're just gonna have to look at a lava lamp and pretend I am the lava lamp. Because otherwise I have to switch it around and then I'm worried that it's gonna mess up. But literally as that ended, it said, this video is unavailable. I know a lot of you probably watched this already. Where are we? I know a lot of you probably watched this already because it is today in Fleisch's court, but we haven't. So I just want to catch up on this. Unfortunately, we haven't seen the other few days, but this is where we're going to be at. Thank you, Court Vibes. That is very kind. I also love Karens versus Karens. I love it. I love it so much. I could honestly watch Karens in court more than soft sits, because soft sits is always the same thing. The Karen is the Karen is going to be different every time, and it's going to be like, wow, that was a whole new level. Court Vibes, was it your video I watched that had the old granny Karen with her dog? Was that yours? I feel like it was yours. Just, it was relatively recent. Okay, let's pop this on. I'm going to try to get the cats back to the cat cam because I want to eat an ice cream and chill a bit. And then it's basically bedtime. Wow, full courtroom. Funny.
Before midnight.
I wasn't in chat, so he's not
Alright.
smiling at my chat.
You ready?
But I did speak to Judge Middleton about Jodi Picoult as an author, and his wife loves her. So just in case you're wondering which judge I was chatting to today.
Herman?
Spanish arraignment,
Okay. Yep, please.
page 30.
Okay. We have a packed house today. What's going on? A lot of arraignments or what? Oh, must be THAs with Ross. Fernando Villegas. Mr. Villegas, you're charged with driving while intoxicated. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer, the lawyer will be appointed to represent you, sir. Okay. Please.
On August 17th, 2024, officers were dispatched to a vehicle crash a little before midnight. Officers spoke with the defendant, who reported that he was driving a 2023 CRV when a 2024 Nissan ran a red light, causing him to strike the vehicle. Officers noticed a strong odor of an alcoholic beverage swaying while standing, and defendant admitted to consuming 3 12-ounce Miller Lite beers earlier. Witness stated that the defendant ran the red light and struck her vehicle. She also indicated the defendant was the driver and the sole occupant of the vehicle. SFSTs showed 6 out of 6 cruise on HGM, 5 out of 8 on a walk and turn, and 1 out of 4 on one leg stand. JC form was read, defendant refused a breath sample, and blood search warrant was executed.
Have you guys seen any prior DWIs?
Okay.
Does he have a valid Texas driver license? You know? Mr. Villegas?
I don't think he does.
No?
On the license portion of it.
Mr. Villegas, tell me, are you a United States citizen? Mr. Villegas? Are you a United States citizen?
No, I said nothing.
Okay.
No.
Are you in this country with or without permission?
No, I said nothing. We just won this.
No. What happens if you go to jail?
I can be deported.
Right. But you will sit in custody for about 6 to 9 months waiting for that to happen. I'm now putting conditions on your bond. If you violate these conditions, I will put you in jail and you will be there for an extremely long time. My only concern are 3 things: that you do not drive because you do not have a Texas driver license. Number 2, do not consume alcohol or illegal drugs. And number 3, do not pick up any new cases. As long as you can abide by these conditions, you will be fine. But if I find that you start acting a fool while you're out there in the free world, I will take the free world away from you. And I'm going to tell you, jail really, really sucks. Do you understand?
Yes.
You will be signing an affidavit with me today, promising me that you're not going to drive. Above all else, I don't care what's going on in your life. If you don't have a license and liability insurance, do not drive. If you can get a license and insurance, come back, show me, and then we can talk about you driving. But until that point, don't drive. You have a lawyer. Herman will take care of you. All you need to do is stay in contact with him. If Herman tells me that he can't get a hold of you because you're playing games, likewise, I will issue a warrant for your arrest. You will not get any more PR bonds.
Judge, may I ask a question for Mr. Villegas?
Sure.
His appearance is waived going forward, but already got a reset date. Yeah, I just wanted to do it for him. His benefit.
Yes, so that's why I'm saying, Mr. Villegas, I will waive your appearance. You do not have to waste your time coming to court once a month while we try to get evidence, but you must remain in contact. And what's what I'm telling you. If Herman tells me you play games, that you're not responding to phone calls, text messages, we will just issue a warrant. That's it. I will have you come up here, swear to us that you're not gonna drive. You will get to Victoria. We're gonna have you sign a reset. After that, my life, you're back. I love it. You will get with Rachel for your bond conditions, and after that, you'll be free to go.
Where do we go first?
Rachel, so happy to have you. Happy Monday. Now we're gonna have a happy Monday.
Council, do you have an arraignment? Last name? Melger. All right, Judge, page 18, Melger, come on up. No, yeah. Oh, Victoria. Good, Your Honor.
Hi, good morning. Daniel Melgar.
Yes, sir.
Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. Okay.
On August 18th, 2024, at about 7 p.m., officers responded to a traffic collision call. Firefighter advised that he observed defendant behind the wheel when he arrived on scene. Officers observed slurred speech, strong odor of alcoholic beverage, and red, watery eyes. Defendant stated he was on his way home to Spring from the Astros game and said he consumed one margarita. The accident occurred in Baytown. The SFSTs showed 6 out of 6 on HGN, 5 out of 8 on walk and turn, and 3 out of 4 on one leg stand. The BAC 24 was red, defendant consented to breath sample, and BACs were 0.167 and 0.161.
Okay, any prior DWI? Mr. Melgar, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
Sir.
Do you have liability insurance in your name?
Sir.
You're not allowed to drive unless you have both. I am, like I said, I'm finding probable cause. I am ordering as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If you test positive for any kind of alcohol or dope, you will go to jail. No questions asked. Do you understand?
Sir.
If you have a lawyer, it's your responsibility to stay in touch with her, and she will tell you when you have to come back to court. Don't pick up any new cases. You know what's expected of you.
Sure.
If your license does become suspended between now and your ALR hearing or whatnot, you're not allowed to drive. And we will make that a condition of your bond as well. For now, we will have you go to Victoria. Guys, have you run his license, Pavel? Make sure.
You don't have any driver's license information.
Yeah, do you mind sharing your license so they can just verify it? And if so, then we'll allow you to drive. Once you do that, we will have you go to Victoria, sign a reset. You'll eventually get with Rachel for your bond conditions, and then you'll be free to go. You must stay in touch with counsel. If they tell me they can't get a hold of you because you're playing games and not responding to phone calls, text messages, I will issue a warrant. Understand? So I'm waiving your appearance. You don't have to waste your time coming in.
Thank you.
You have to stay in touch.
Thank you, sir.
Thank you, Judge.
Thank you.
All right, Judge, page 14. Terrell. Felix.
What page did you say?
14, finding page 14.
It's eligible. You got it?
It is eligible,
Great.
yes.
Thanks, guys.
All right.
Hey, hold on. Get him up, but I'd like to send Mr. Jones for a drug test. Yeah, this is the gentleman remember Mr. Jones? Can we send him? Yeah, if we can just get that going so we can have him back. Yeah, and then, but yeah, come on up.
Oh, okay. Page 14, Judge.
Okay. Well, you're not Cesar Hernandez. You must be Felix Iterel.
Itero Felix, yes, sir, young.
Is it Iterel?
Itero.
Itero.
Yes, sir.
Sir Itero, you're charged with criminal mischief.
Yes, sir.
You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On August 12, 2024, officers were dispatched to a criminal mischief call at an apartment. Officers made contact with the complainant who advised that her baby's father kicked in her back door. She advised he did this to search for money that he gave her to buy the clothing for the child. Complainant had already spent the money, so the defendant didn't find it. Defendant then left the apartment after gathering his belongings. The complainant identified the defendant by the photo, and the total cost of damages was $976.
You know whether she wants to have contact with him? Have you guys been able to?
She's with me, Judge. Your she's with me.
She's here now. You guys want to go try Rip real quick? All right, so I was gonna bar her from having any contact with you unless I know that she wants to.
Yes, sir.
We can send one of the DAs to go have a talk with her now, and then, so Miss Idarel, I am going to find that there's probable cause to go forward with your case. Do not pick up any new cases.
No, sir, no, sir.
I don't want to have to revoke your bond,
Yes, sir.
okay? So what do you do for a living, sir?
I work, sir. Got 2 jobs. I do home or health care from 4 to 7, and from 11 p.m. to 7 p.m. I do night watching for real estate company. James Thibodeau.
Can you afford a lawyer?
Oh, yes, I have one, Lot Brooks, Mr. Lot Brooks.
Have you already hired him here?
Oh, yes, sir. He said he was gonna come.
So let's do this. I'm just gonna have you take a seat in the pew over there. We'll have you sign a receipt, but don't leave.
Yes, sir.
Otherwise, I'm gonna issue a warrant, and then we'll wait for Lot to come, okay?
Thank you, Your Honor.
For sure.
Right this way.
I guess we'll wait. I don't know.
Yeah.
Next is page 21, Perez. Natalia. Sally.
Ms. Perez, you were charged with racing on a highway. Your case is nearly 500 days old, and you have taken off on me over and over and over. We decide today what happens with your case. Take a seat for me in the jury box. You're not allowed to leave.
Next judge is page 27, Tyrell. Ian, come on up. That's it.
Okay, do we have THAs?
Yes.
Let's do it.
All right, we have first one on
Just doing
page-
THAs now, so.
page- I know, you just said Page 1, Baltazar, come on up.
Hey, Vic. Good morning, Mr. Baltazar.
Good morning, Your Honor.
Do you have a lawyer today?
Sir,
Tell me what you're doing about that.
I'm hiring this week, but I sold the vehicle. I have the plates. I have a new vehicle. I have everything registered under my name.
Can't talk to you about the case. You need a lawyer to represent you. Okay,
can
I
get
don't
the-
make the deals with you. It's the DAs and
I understand.
you know what I mean? How old are you? What do you do for a living?
I'm currently unemployed right now.
Why?
Due to this, I was working at FedEx, but I quit it due to there's just too many problems. And right now I'm trying to apply. I'm trying to get rid of this case so I can be a driver, a truck driver.
You're going in circles. You quit your job. You're not making any money, but you need a lawyer to represent
I
you.
have
And lawyers don't work for free.
And I have money saved up for a lawyer. So I was gonna ask if I can have a reset.
Who do you live with?
Parents.
Did you graduate from high school?
Yes, sir. Sorry, what was that?
Want me to appoint you a lawyer?
No,
Like a court-appointed lawyer?
I can hire one.
Okay, all right. We'll give you another month. Okay,
Thank you, sir.
when you come back, please have a lawyer. Okay,
Also, I have the driver's license and insurance that you asked me to prove. I have that on me with me today.
okay, let me take a look.
I have it on my phone. Can I pull it out?
We driving affidavit, so he was driving in.
Actually, no, my driver's license number. Do I mind sending it to you? That's my picture on my ID, but that's my driver's license number.
Do you know how to run a license? It's Ileana, right?
Yes, Judge.
Do you know how to, on Mr. Baltazar, can you run his license to see if it's eligible?
May I have the,
And then you said you had liability insurance in your name?
Yes. It's 487-531-80.
Okay.
Yes.
Will you help the lawyers so they can get out too?
Yes. Council for a reset?
And this is my insurance right here, ma'am.
You need me or do you want? She's ready.
Sorry if I can-
Michelle, look, can we help you? Oh, for that thing? Okay.
insurance is covered, Judge.
Okay, have you been
And
able
the
to verify the
driver-
license? Let me see, I want to see the insurance though.
The driver license is eligible.
Okay. Thank you. Okay, good job. All right, we'll allow you to drive. Just maintain liability insurance while you're driving the whole time. Don't let it lapse. If it lapses, meaning that if you don't pay the insurance and it goes out, no more driving. I will make a notation now that we are allowing you to drive. And then we'll just have you go sign a reset and then you're good to go.
Thank you,
Okay,
sir.
all right, Mr. Baltazar, good job.
Have a good one.
Yeah.
We're on Samantha Salazar. That was the AJ hearing previous reset. You can see if you want it. If you don't want it, I already made it. So it's up to you. Whatever you drink today. Yeah. Yeah. I'll talk to you about it this afternoon. If you want it, I'll give it to you. If you don't want it, I'll do it. To get reset, did you talk to her about Wednesday or Thursday?
Sorry.
Any preference?
She said a couple of days. I prefer Thursday.
Okay, Mr. Ela, good morning.
Good morning, Your Honor. I'm here on Samantha Salazar. We're set for a hearing today. I tried to get in contact with her yesterday.
She's not even here.
She's not even. She did text me this morning at about 7 saying she had a stomach flu, and I do believe her. I mean, she doesn't have any proof. But
That's it.
I understand. Well,
Get her.
Should we SFBF of Wednesday?
No,
Okay.
no, she's on probation. She picked up 2 assaultive cases. And are they felonies or misdemeanors? I don't even
It
remember.
was injury with a prior against mom and injury to, or assault with a prior to mom, injury to the grandma, so elderly. She ultimately pled to the injury to the elderly.
She pled?
But deferred to that, yes.
Wow. Salazar's the last name, right?
I'll be honest, Your Honor, I wanted to litigate the whole thing. Frank.
I mean, upstairs?
No, well, I mean,
Well, he was
I'm
a counsel
upset that she
upstairs.
pled out because now I can't even, now I don't know if I can plead untrue to all of it, but
That's the allegation that we will go on now.
I understand.
So now she made a 10,003 bond now. So I'm setting it at 25,004. And we'll get it when we get her.
So in the meantime, are you gonna stay on? You know?
I'll stay on. I
Okay,
mean, I'm-
if it's
That was
this
our
week, I mean,
show.
I would like to do it this week, but
Yeah.
I guess
just
we
call it. I
probably
mean,
can't do that. I mean,
she'll just need to.
And then,
I guess, turn herself in
deal with it when we
Wednesday,
get her.
Thursday, or turn herself in Tuesday, do it Thursday, something like that. If you still want to do it Thursday.
Now we will go forward
Because
on
my-
what she pled.
Right there.
She pled to the injury to a child, or she pled to the injury to the elderly, so that's it. Okay, guys. Mr. Elick, do you want to stay on? Do you want to?
I'll stay on, Your Honor, and I'll try to have her turn herself in, and I guess we'll reschedule.
No, there's no rescheduling.
No reschedule.
Because we issue the warrant, it'll just stay in warrant status until we pick her up.
Well, I mean, when
Well,
she turned, in the
well,
event that she
If
gets.
she turns her in,
If she turns
Yeah.
herself in, then I can.
and what we'll do is we'll just go through the whole, dog and
get-
pony show and yeah. That's
Yeah, I
it.
was hoping he'd stay on since he already has access to everything.
I mean, I've already prepared.
No, and please do. Yeah. Okay, thanks, bud. And then we'll just reach out to you. I'll let you know when we do get her. Or you,
I mean, would the court prefer her to turn herself in court, or, I mean,
it would probably be, I don't know what she wants to do, right? Probably the cheaper way would be to do that, right? So that she doesn't have to pony up 25 for,
I mean, if we just show up, if she shows up, can we just have a hearing, or does she need to get, go into custody and?
if she shows up today, we can have the hearing, right? If she shows up post today, no.
Then we'd have to get it, set at some
And
point
I'm
for a hearing.
putting her in jail and then we can have the hearing.
I mean, if she's, I don't think she has a doctor's note. I mean, I understand. I mean, it's what it is.
Okay, thanks, Coach.
Thank you.
Josh,
Morning, Judge. How you doing?
hey,
I'm here on Mr. Last name is Tyrell. Ian Tyrell.
this is a new case.
This is a new case.
Tyrell,
He's in the courtroom.
you mind bringing it up? We have to do probable cause.
Sure. Mr. Tyrell?
I want to say that we know Mr. Tyrell, right?
Judge, I'm doing his felony case as well.
Okay.
That case is set for September 26th.
Got it.
He already has conditions on that case.
Yep, I remember Mr. Tyrell. Yep, he has picked up a disorderly conduct with a firearm where we had to revoke his bond multiple times for his failure to appear and or bond violation. So, Mr. Tyrell, you're now stand charged with interference with the emergency request for assistance. You're facing up to a year in jail and or a $4,000 fine.
Sure.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You also stand charged with an assault of a family member impeding breath. So let's do it. Ms. Elaine.
On August 18th, 2024, officers were dispatched to a disturbance. Complainant and defendant are dating. Complainant advised she went through defendant's phone and saw messages the defendant was sending to another girl. Complainant threw water on defendant's face as he was asleep, and an argument ensued. Defendant grabbed complainant by the neck with his left hand for about 5 seconds, causing complainant pain and preventing her from being able to breathe. Complainant attempted to grab her phone to call the police, but defendant took the complainant's phone and keys to prevent her from making the call. Complainant ran outside and was able to get help calling 911 from a neighbor. Witness advised she observed complainant sitting curled up in the hallway, and witness asked complainant if she was okay. Complainant stated she was hiding from defendant and asked if the witness could call the police.
Mr. Terrell, I'm going to find that there is probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand? Sure. You're also ordered not to have contact with this person as well. Sure. I am also. Val, can you file a protective order in this place? This emergency request?
Judge, was it?
Terrell, I'm ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand?
Sure.
Okay, so Yasha, do you want the same date as a felony?
Please, Judge.
You must stay in contact with counsel. If he tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. I'm not going to play games with you, Mr. Terrell.
Sure.
I'm not going to play games with you like we did the last time. The first instance you start toying with us, I'm going to make your bond so high, your head will be spinning round and round and round it goes. Do you understand? I will first have you go to Victoria. We're going to have you sign a reset. You will then meet with Rachel for your bond conditions. After that, you'll be free to go.
Okay, thank you, Judge.
Hey, Will.
Hey, Judge, how are you?
Good morning.
Approaching on,
No? Right?
no.
Oh, no?
Should I be?
No,
I
don't-
hope not.
I
God.
figured you would be. That's,
No. He's supposed to be transferred on Wednesday, I think.
so are we all good on Mr. Patel? Yeah, okay, great.
Not that one. Mr. Calhoun is who I'm here on. Give me a heart attack, Judge. Come on. He's custody.
Custody. 76? What?
36.
Oh, 36.
Don't scare me either.
What?
We all good? Everybody good? It's Monday.
So let's, tell me about Mr. Calhoun.
So just pointed to his theft case. He has, I think, at least five pending felonies. His bond's been denied on most of those. He has a setting on 828 on the most recent one. The case is very old. Just spoke with him. He also has a parole hold.
I've been busy, huh?
Yeah.
Okay,
Victoria
I'm
asked
not
me-
gonna, they gave him a PR bond here in this case. I'm not giving him a PR bond.
That's fine. He knows.
He's not
the
going
game.
anywhere anyways, right?
Yeah, he's not. His bond's been denied on at least 4. Right?
5 cases. What happened? Why?
I mean, because he has so many. He's got. It's like he's just a serial car thief, carjacker.
Okay.
Allegedly.
So it looks like the felonies are set for 8/28. You want to do sometime next week and then we'll see where they go with that and then we can set it?
Sure.
Yeah, okay. I'm gonna set his bond at 1, 2, 3, 4, 5, 5,006. Okay, just so you can tell me. Hey. Did you give me glasses? I like your glasses. So 5,006 on Calhoun.
And they offer their classes.
Okay,
Hey, Mr. D. Ben?
Got a plea on Mrs. Aaliyah Pendergraft, Judge. We're proceeding on the theft case, and upon completion, the state will be dismissing the criminal mischief case. Time served.
Ms. Pendergraft?
Yes, sir. No, so to the judge.
Ms. Pendergraft, you're charged with theft, you're charged with criminal mischief, you're facing up to 6 months in jail and or a $2,000 fine on the theft. Looks like as part of the agreement, they're going to dismiss the criminal mischief. How many thefts does this make for you? You know what happens next time?
Yes, sir, I'm aware.
What happens next time?
It's prison, and I'll do prison.
If you steal a $5 pen from Walmart, skip scanning, you will be looking at years instead of days. Next time you get the itch, find another release, find something else to do. Because it's not worth it. Do you understand? You're giving up the right to a trial, right to compel witnesses testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequence. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. This will go on your record. From now on, you'll be facing a minimum of 90 days in jail for any cases that you pick up here. But like I said, you pick up another theft, you're looking at years. Do you understand? How do you plead to the offense of theft, man?
Guilty.
I will find you guilty.
Mine is credit for 14.
You said 14 or 4? So 9 days in jail. You said 4.
Yes.
4 days credit. You will be walking out of here today. I'll roll your court costs so you won't earn anything. But like I said, do it next time. Good luck. Thank you, Mr. Dean.
Yes.
Hey. Hey, bottom of 15, BVR.
Yes.
Check in. Both. Bottom as well.
So both checked in, yes.
Okay. Ernesto Leon. Come up. Take a seat for me in the jury box. You're not allowed to leave.
Joe, I'm going to put 2 to do a driver's Remember, I told you she was in
taken into custody, taken to hospital, they used to be there, but his status is still-
Okay. Yeah.
So.
That was
he's here today.
Friday?
Yeah.
Okay.
But the case was- It's her, so I want to give it back to her. But here's two cases.
Okay.
You want to call him?
Yeah. And then also, let's get, hey,
No.
let's get cooking on the,
Yeah, we can do that. This one was a problem that might take a while to resolve, like as far as the warrants and then the funeral. But we can definitely start Tuesdays again. 25, 24, 264. Turner, come on up. All right, so it's two cases.
So this is the correct, she's been dismissed, Matt Future.
case has been dismissed?
Yeah.
We've done PC on this case already, though.
Yes, because he came in for his 7-day setting.
Right.
The statute is all messed up.
Okay, so
Good morning, Judge. I was also going to ask if we could maybe consider modifying his bond conditions. He drives a non-driving affidavit, but he drives for work and he also takes care of his mom, who is disabled and handicapped.
does he have a Texas driver license?
Yes, he does.
Does he have liability insurance?
Yes, yes, you are.
Does he have any open DWIs elsewhere?
No, sir.
Pavel, did you get this cause number?
No, Judge.
Can I give it to you and just run an NCIC for me, please?
Sure.
2524264.
2524 what?
2524264. Yeah,
NCIC for fires?
yeah. Anything else open anywhere else? I don't have notes on why we did the no driving affidavit.
Yeah, he did it before I got here, so I wasn't able to speak with
You
you.
do it for a reason. I don't do it just
Yeah.
for the, shits and giggles. It's got, there's got to be a reason, right?
He was driving pretty fast. He was going about 100 miles per hour. So we do understand that.
Was it just about 100 or was it 120?
No, the report says between 100 and 110. It doesn't state an exact number.
Your Honor, he doesn't have any prior DWIs. The only cases I see are two dismissed cases from the 90s.
Okay, and in this case, how fast is he going?
Judge, on this case,
From between 100 to 110 miles an hour.
And that's why we did it. Weaving in and out of traffic. And if I remember correctly, he also had booze in the car with him, right?
Yes, sir.
No. Sorry. Actions have consequences, Mr. Turner. You could likely kill someone at that with booze in the car. I would think that it's elementary that you would know above all else that we're not supposed to have alcohol in the car while we're driving, going 100 to 110 miles an hour, weaving through traffic. I want you to appreciate the awesome power and privilege it is to have the ability to drive. It is not a right. It is a privilege. And we in Harris County lead the nation in fatalities related to drunk driving because of this very fact pattern. So I want you to appreciate it until I know that you do, ixnay on the driving aid. Do you understand?
Yes, Your Honor.
There is an affidavit, and I'm going to tell you now that if I find you driving, I will have a contempt hearing. You'll be facing 6 months in jail every time you drive. I want to know that he appreciates it at some point. Come back to me and then we can talk. But,
Yes, sir.
a day, 2 days, a week, 2 weeks, that's just not enough for him to really appreciate it is. We live in a really, really big county where it's, not having the ability to drive really, really sucks. And I want you to appreciate it. And when I get that and when I know it, then we'll talk again. Understand?
Yes, Your Honor.
Good luck, Mr. Turner. Okay. So we'll just give you a normal reset. I will waive your appearance, so you don't have to waste your time coming to court, but you must stay in touch with counsel and they will tell you when you have to come back to court. If they tell me they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. So maintain contact and they'll tell you when you have to come back to court.
Yes, Your Honor.
Until that point, show me that you appreciate it and then we will talk.
Yes, Your Honor.
Okay.
We were here today where she said the system stuff he didn't fill out, and so.
Do we need to give them a PR bond or what do we need to do? Okay, so we'll issue a warrant. Bonds are already set at $100 on each. So we'll just leave that as is, and then we'll give you a PR bond now. I'm not gonna give you another one. If you pick up a new case, start acting like a fool in the free world, I will take the free world away from you. No more PR bonds. You understand?
Yes, Your Honor.
Okay, we'll give you 2 PR bonds now and that's it. Okay, so just don't leave. We're gonna have to do a bunch of paperwork with you. And at that point, if you want to go ahead and pick a reset date, we'll give you, 45, 60 days, whatever you're happy with, whatever you're happy with, and then we'll go from there. Okay, yes, ma'am. All right.
So if you'll just give Rachel the case number. And all right, Judge, you want to start CHA?
No,
Yes?
yes.
All right, page 2, Beltran, come on up.
Mr. Beltran, do you have a lawyer today? That's it. Your case is 71 days old. We will move forward with trial if you don't have it. Do you understand?
Yes, sir.
2 weeks. That way.
Right this way. All right, so next is page 8, Davis,
Mario Betancourt.
Travis, come on up.
Did Betancourt check in?
No, Your Honor.
No, Judge.
Okay. I need to know if so it goes in this way, sir. What was your last name?
Page 8,
Davis.
Davis.
Okay. All right, good morning, Mr. Davis. Tell me, do you have a lawyer today? Sorry?
I don't have one.
Tell me what you're doing about that.
Working on it. Some of the payment plans I can't afford right now, so therefore.
How do you survive? Sorry?
But you took that privilege away, so I really hadn't been driving too much, so.
Did I take that away or did you take that away yourself, Mr. Davis? You're gonna blame it on me, like all your other problems?
I'm not blaming it on you.
But you just did.
Sometimes I can't even speak without being cut off. It may seem like I'm being a bad guy about it. But then yet, if I'm saying what I'm saying right here, right now, I blame you for anything. Take responsibility for everything I did done. Sorry. So I just need a little bit more time.
You told me just now that I took your mobility away. You were the one that is charged with your second offense of driving on a suspended license and then fleeing from an officer.
Fleeing, man.
I'm telling you what you're charged with.
I'm telling you what I wasn't doing.
Okay.
It's not true. Check your video cam, and when they get the lawyer, they will show you that's not true. And then yeah, when they
Doing
pull
life,
me,
Mr. Davis.
huh?
What are you doing life?
I'm a barber, caterer, a lot of things. My HVAC work, but it's like right now it's slow because I'm not mobile. But I'm being honest with you. I'm not trying to be disrespectful. But dang, can I raise my hand and say something? That's all I'm trying to say.
I don't want to
No
talk
harm.
about the case because I've got a
All
bunch of DAs here.
All right.
The only question is how much money do you make a month?
I already told you that. Then you said I couldn't afford a public defender.
I'm not gonna, with your attitude, I was considering giving you a lawyer. Now I'm gonna get you out to reset. And I'm gonna tell you this now. Your case is 109 days old. I will bring you back to the next setting. And then after that, we're gonna set your case for trial. So get ready, Mr. Davis. Over there.
Judge, what's up with this one?
Attitude, that's what's up. The next time you will be held in contempt.
How much time, Judge?
30 to, no, 2 weeks.
All right, Judge, next is page 12, Gonzalez, Adam, come on up. All right, go ahead and send me your receipt, please. Thanks.
Okay, what is your last name, sir? Gonzalez. Okay,
Page 12, Your Honor.
thanks. Okay, Mr. Gonzalez, do you have a lawyer today?
Sure.
Do you have a lawyer today?
No, sir.
Tell me what you're doing about it.
Tell me what I'm gonna do.
You need a lawyer to represent you. You're facing 6 months in jail. And what have you done to find a lawyer?
I've been calling around trying to get like the best price I can
Okay.
see.
How many people have you called?
So actually they've been calling me, so I've just been kind of talking to them and seeing what price works best out for me.
Okay, and what have you found?
It's a little bit too expensive right now, but still looking.
You need to call more people. 99% of the lawyers in Harris County will put you on a payment plan if you ask. You pay a couple $100s a month, they'll represent you in this case. You just need to find the right lawyer. You need to start calling 20 people plus to find out, but at some point you will find someone that will represent you. Just negotiate with them. Don't take them at first blush. You need to start calling around more. You understand? Okay, I'll have you go to Victoria. We'll give you more time. We'll give you another 30 days. Start calling around. Okay? All right.
All right, Judge, next is page 19, O'Connor, come on up.
Good morning, Mr. O'Connor. You have a lawyer today. Tell me what you're doing about that.
But you say it was too soon, so you said go to court, get a reset, then you can do it after.
So we'll give you another setting. You'll have him or her. Okay. You want to head on over to Victoria. We'll give you another setting.
Next time you say I need insurance for you.
Do you have a valid Texas driver license? Okay. You have liability insurance. You want to drive?
Yes, sir.
Okay, let me see it. And then if you have it, then we'll allow you to drive. Thank you, sir. Is your name on this thing?
Yes, sir. It's on the next page.
So you have the ability to drive all these cars?
Yes, sir.
Wow, that's pretty cool. It's like 15 different cars. Not bad. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Okay, we'll take it off. We'll allow you to drive. Okay, just maintain insurance the whole time and then we're good. And as long as your license is valid too, then we're okay. All right. I will make a notation now that you have the ability to drive. Just be careful, okay? Allowing him to drive, I'll make the notation. That's top of page 19. Yes. No, I've got Marcos here. Marcos, ready?
Judge. Judge, I'm working on Mr. Edson Perez. That's all.
Okay, you said Perez, right?
Yes, Judge.
Okay.
He has already signed the PTI agreement at my office. We're just requesting additional time for him to get the interlock on the car and pay the DA fee.
Is the last name Perez?
It should be, Judge, yes. Perez.
You sure it's not a different name?
Elizondo? No.
Okay, it's 212. How long do you want? Thank you.
2 weeks. 2 weeks would be good, Your Honor. Because his car's in the shop. He should be getting it out this Wednesday.
Okay.
And he should be able to get the interlock and pay that fee.
Got it. Okay, after that though, that's it.
I
Is that the
understand.
time after that?
I understand. Thank you, Judge. May I be excused? Thank you.
Good morning, Judge.
Hey, I'm ready.
Yes, sir. I was just giving the state a heads up. If I may go.
Okay, tell me.
I have an off-docket request, but an urgent one, if I may.
Okay.
What
What's
the calls
the
are
request
right?
number?
It is 251-8349. Yes, sir.
Okay.
So on presently, so Mr. Evans, by way of background, he does have a.
It's in treatment, correct?
Yes, sir. Thank you for remembering.
Yeah.
He's successfully completed treatment. He's participating in aftercare program. He's going to meetings. As the court may recall, Mr. Evans is also an officer of the court. He and his wife is from Canada, which is where DWIs is pretty much a no-no. We do have the interlock on presently. He had a previous DWI from 10 years ago that was dismissed. I think was what gave the court concern. What we're asking, because we're trying to kind of, for the time being, keep Mr. Evans' driving record and criminal record clear of evidence of the DWI so that he can enter Canada eventually with his wife and family. We would ask that this court remove the interlock.
I haven't even seen him. He's never even been here.
Oh, yes, sir. He's here now.
Is he here now?
Yes, sir.
Right, but have we done, has he signed conditions or no?
He signed bond conditions the first time, and he was here in person. The second time after he entered treatment, I came, the court waived his signature for obvious reasons because he was in treatment. He's been completed the treatment program almost 2 weeks ago. We're not on docket yet, but we essentially, if he still has the interlock.
Why do you want me to take the interlock off?
Because if he still has the interlock on his vehicle, if there's not an order removing it by August 30th, then DPS will suspend his license and that will be on his record as the reason. So then eventually it'll cause him problems when he's trying to
they won't suspend it just because of that. I mean, unless he's got to send in the $10 fee, then they won't suspend his license.
Well, Your Honor, there is the matter of the SR 22, the $10 fee, but it will also create the record on his driver's license, which is part of the issue here, because his wife is a Canadian national. He's
At the ALR hearing, though.
The ALR hearing is set for this Thursday, but that would be just on the refusal, the separate matter of.
It'll still suspend his license, though, if you lose it.
Unless.
No. And that's not because of the interlock. That's just the ALR hearing. If you lose the ALR hearing, his license is going to be suspended regardless. Take a breath test.
Sorry?
Do you take a breath test in this case?
No, sir.
His license is going to be suspended for 6 months.
Well, Your Honor, we do have the ALR hearing. If the department is able to meet its burden, then yes, it will be suspended, but there is a good chance that it won't. And I'm an optimist. I think that.
Sure. Let's do this. Do the ALR hearing. Let me know what happens, and then we'll come back. If I do take it off, I'm going to put a scram on him so I know that he's not drinking. So because of the issues that he has, I don't want to let him go without anything. I want him to have one thing or the other. I mean, he can choose. The problem is that I don't want him getting in the car if he's had alcohol on board, right?
Of course.
So I'm going to give him one or the other. It's going to be, he can choose which one he wants to have, right? But let's not put the cart ahead of the horse, right? Have the ALR hearing. You said, when is it, this Wednesday or Thursday?
Thursday.
Okay, let's do this. Come back to me on Friday. Okay, he doesn't have to appear. We'll waive his appearance because it's not old, right?
It's July 4th.
He's not undocumented, right?
Yes, sir. Right, so we can because he.
Yeah, so let's do this. Have your ALR hearing, come back, let's see what happens. Because if it gets suspended, it's going to get suspended regardless. It's the interlock portion is irrelevant to whether it gets suspended or not, as far as the ALR for ALR purposes, right? If you want me to take it off, I will, but I'm going to put the scram on it.
There's nothing I can say to persuade the court
No,
otherwise.
not with the prior DWI and with the fact that he's in treatment and he has issues. You know, I have a concern, right? And I don't want him using. And I want to know, and I'm not going to take his word for it that he's not using. I don't want to take it. I can't take his word for it. I have to have something on him to know that he's not using.
Sir.
Okay. Thanks.
Take your time.
Yeah.
All right, Judge, ready for the next case, Jay?
Yep.
Page 26, Torres, Daniel, come on up. Hi, Real.
Good morning, Mr. Torres. You have a lawyer today?
Yes, sir.
Oh. Okay, so just go ahead. Who is it?
Brian?
And who?
Brian starts with a C.
Brian starts with a C.
Yeah, my phone's on as well. Brian,
Who's Brian starts with a C? Lawyer. You sure it's not Dan?
no, sir, it's Brian.
All right, well, just go ahead, take a seat. When he gets here, then
I'll turn my phone on and look it up.
for sure. Hi. Ma'am, you're not allowed to leave. I mean, she has a warrant. So.
The last.
Sanchez, Mary, come on up. Sanchez.
Nasha. Hey, your guy took off without signing the mower. I need him back. Can you please just tell him to come back? Yeah. No, he left. No. Let him know he's gonna come back, otherwise we issue, okay? Thanks. Okay, bye. Sorry to keep you waiting.
Approaching on a motion to sub for.
I signed it.
Okay,
Yep,
perfect, thank you.
Thanks. Hi, Anna. Good morning.
I'm here on Mario Garcia.
Garza, Natalie, come on up.
He's on bond or in custody?
He's on bond.
Oh, is that the gentleman over there? Okay, how goes it?
He is, let me see, he is done the social studies piece, the language arts piece, and the math piece. So he's slowly chipping away at the GED. Today was just the check-in to see how he's doing.
Or is that it?
There's still the science piece.
How's he doing with that?
I believe he's started working on that piece now, but he's done the other three.
Come up. Hey. Tell me what's going on with science.
Science, I'm waiting on the voucher to receive it from the case trio. Once I receive the voucher, I'll be able to take it as soon as
What does
possible.
that mean? You're waiting on the voucher?
It's so I don't have to pay fully out of my own pocket to receive the, to take the test. So they're gonna be doing it for free because I'm under a case trio with HUC, so they're trying to help me with the best of their ability. So I can get the test done.
Do you know
without
when
any
that's gonna happen or no?
As soon as I email them, I have to give them these four dates, which I took last night. Of course, it takes some studying to do, and I did pass it.
Right, good job.
So as soon as I can email her and let her know that I need to do the one for the science, she'll give it to me. And then after that, I can take the full GED test. But unfortunately for my language arts part, I did take that test back in 2019 when I was incarcerated. So I may have to take that one again because I think they say you have to do it in 6 months before taking the test. Like all scores have to be done. So that's another voucher I'm gonna ask for. But I did pass that one, so it should be as easy to pass it as it was before in the
Okay,
past.
so if we give you 2 weeks, you think you'll have science done by then?
Yes, of course.
Okay, let's do that. Okay, good luck.
Thank you, Your
All
Honor.
right, make it work. Come on, you're so close.
So close.
2 weeks, please.
Thank you very much.
Hey, Corey. What's up?
Mr. Dorsey in the holdover, there's a motion to adjudicate.
Sale or display of harmful material to a minor. That's what he picked up. In Harris County or somewhere else? 'Cause-
And that's what he's playing guilty to.
Dope. So what, you don't know what the disposition of that was though? Was that a misdemeanor or felony?
I'm not sure if
It's
it
a
was, I
misdemeanor.
didn't look at the JS, I'm not sure if it was sent on 1244A or if it was just a misdemeanor.
No, I think it's just a
He did, you saw 20? How much credit does Mr. Dorsey have then? Do you mind checking? Jacob Dorsey, how much credit does he have? What is it?
99.
You want to just do 100 credit for 99? Yeah, let's do it. And then, yeah, we'll just unset term.
We need to fill out any paperwork on my.
Yeah, there's a stipulation and then the waiver.
Okay.
Yeah.
Okay, all right.
Okay. Any more THAs?
All right, Judge, page 20, Ortiz, come on up.
Man, we're going backwards.
Juan Ortiz.
Did we not do a Torres? Good morning, Ms. Ortiz. Do you have a lawyer today?
I do, but she says you want to do a motion to reset or something like that.
Okay, who is it? Who?
Marty Garcia?
Marty Garcia?
Yeah.
I don't know a Marty. Are they going to be here today? Do you know?
I don't know, Your Honor. She just told me to show up.
Have you paid him any money?
Yes, Your Honor.
You gave him money?
Yes.
I would assume that he's gonna be here. Do you want to call him and see if they're gonna come?
She said she was gonna do a motion to reset or something like that. I don't know.
First thing they have to do is they have to sign on to the case, attaching them as your lawyer. I don't see that they've done that. Do you? On top of page 20, Juan Ortiz. No one has filed any kind of documents. No one has done a motion for a reset or anything. You want to reach out to them and see what's going on? We don't have anything yet.
Okay.
Typically what happens is the lawyers will appear either Zoom or they'll come here to file the motions, but I don't know. Reach out to them and see if they're gonna come, and then, if they're not, I can give you a couple more weeks for you to, try to get them here. I don't know.
Your Honor, I think she's in court, so you might not answer me. I think that's what she said. She was gonna be.
Perhaps they have an assistant or someone that can give you more information. I don't know.
Okay.
Yeah, I don't want to just, I don't want to reset you in the event that they come here, you know? So let's see if they come here. If not, then we'll give you a couple more weeks.
Okay.
Yeah? Okay. And then just try to see what you can do. If they're, call them to see, are you gonna file? Have you done it? When are you gonna do it? And then just let us know.
Okay.
Yeah.
So I just like.
Yeah, just go outside and call. Okay.
Go ahead and sign, please.
Oh.
All right, next is a 26 Torres Daniel.
Oh, he says he has an attorney.
Oh, he does?
Yeah, but he's not here yet. Daniel starts with a C.
Page 27, Olivia Torres, come on up.
Rachel, out of earshot? Out of earshot? I'm gonna go back there or here's go.
You can choose the condition in July. But then again, it says that she's supposed to put in the device. It's a comment section basically saying she needs to put in the device. She knows where to put the device, but I'm just going to indicate why she needs it.
Well, that's portable device. Did the magistrate order it maybe? Huh. All right, I'll take a look. It's weird. Yeah. Ms. Torres, do you have a lawyer today?
No, I was told last month I was supposed to get it.
Hmm. No, not a portable device. You're just gonna get tested. Yeah, so, I can't hear you. You need to speak louder.
No, I was talking about the portable. The last time I got a text message and I told you before I left, and you said that I guess it was a mistake, so you removed it.
There's no portable device. This is an assault case. You know, our only thing is that we don't want you to use alcohol or drugs, and we ordered you not to use alcohol or drugs. So how old are you, man?
19.
Okay, so what happens is on 7/26, we ordered you to go be drug tested and you tested positive. So I will appoint your lawyer today and I'm sending you right now for a drug test again. Okay,
Can I say something? Or no?
go ahead.
Because I have not smoked or at all or anything. And there's like I know I haven't, but I don't know if it's still gonna be my system because the day before the 26th, it was a pen that I had hit, and I know that that does stay in your system longer. But
The day before 26
26, yes,
of
day
what
before the
month?
court date, yes.
Of July?
It's the last court date, yes.
Okay, well, I'm gonna send you now for drug test. I'll appoint your lawyer and then perhaps we'll send you, let's see what happens first and we'll go from there, okay?
Because I know I have it, so I'm just letting you know, because I'm not sure if it still is in my system or not. I'm just saying, I know that that does stay in your system longer than an actual,
Okay, I'm gonna send you now.
Okay.
Come back. I'm gonna give you a lawyer and then let's see what the result says and we'll go from there, okay? All right.
Like leave from here right now there?
No, first I'm gonna have you sign a reset and then we'll just have you take a seat there. Rachel's gonna tell you to go and then you'll come back after you're done, okay?
I'm gonna sign for your recess, please.
Oh, and
Yeah, question.
of course.
Judge, I have on your docket, Bettencourt, BET. This is a bond violation. I did not tell him to come this morning. I was out of town this weekend in Galveston. My birthday's in a couple of days and my wife and daughter.
Emailed you last week to tell him to come.
Yeah, and I did not do it because I left early Friday. So if you will, I can get him in here tomorrow we're gonna close that case up within the next couple of weeks. He's gonna be going into the PTI. He's already signed.
Have you seen the bond violation, Owen? Have
sorry.
you seen the bond violation?
He told me that he had
I'm not
failed
happy.
to blow at one point.
I'm not happy with it.
But I'll get, if you'll let me, I'll bring him in tomorrow morning and
Let me
we can,
see what the reset says, whether he's supposed to be here regardless. He's supposed to be here regardless. On his reset, his appearance was not waived. He's supposed to be here regardless. I'll show you.
okay, Judge, I don't know. Well, I know this is essentially the same thing. Could you put him on bond forfeiture for a week then? I'll get him here. Because we've already, I mean, we've signed the contract.
I'll put it tomorrow.
He gave me $300 to pay the fee. I'm expecting to have an interlock device in the car.
Owen, I'll roll it to
Okay.
tomorrow.
All right.
Okay.
I'll
Let him know he's got to be here tomorrow.
have him here tomorrow morning, Judge.
Are you okay?
Thank you, Judge. That's the court.
Judge, you ready for the next CHA?
Okay, yeah.
Right, page 29, Ventura Lopez, come on up.
Sir,
More.
you have a lawyer today.
Oh, no comprendo mucho inglés.
Tienes un abogado.
Okay.
¿Qué estás haciendo con eso?
No tengo abogado, no tengo dinero por pagar.
¿Necesitas un abogado?
Ya.
Es posible que tú andes a la cárcel por 6 meses o más. ¿Qué estás haciendo acerca de eso?
No puedo tener dinero por pagar.
¿Qué haces?
Oh,
¿A qué te dedicas?
al trabajo, pero no, un poquito.
No me estás respondiendo a nada. ¿Qué haces en la vida? ¿Y cuánto haces? ¿Cuánto ganas?
Gano 15 la hora.
¿15 qué? ¿Dólares? ¿Centavos? I mean,
$15 la hora.
¿haciendo qué?
Construcción,
¿Cuánto por mes?
2,500, por ahí.
¿Que no puedes pagar un abogado?
Ahorita no he tenido trabajo, estaba enfermo. No he trabajado mucho. Malo de espalda.
So, ¿cómo vives entonces? ¿Cómo comas?
Por lo poquito que voy para gana mi esposa y trabajo, y a veces trabajo yo poquito.
Anna, do you mind running his license, please?
No.
We do not have that driver license number.
Okay, I guess this must have been an arraignment when someone else was here. So, do you mind reaching out to, I guess, Luis? Señor, tome asiento para allá, por favor.
Thank you.
I'm going to give him an application, but I need him to sign a no driving affidavit. Do you have one in Spanish though?
English and Spanish.
Oh, is it? It's dual?
Yes.
Are you ready for the next one?
Yeah.
Page 30. Oh, come on up.
I mean, after today, I'm gonna need some greasy fried chicken. I'm gonna tell you what, from that Popeyes or KFC. I can't deal with it. I need some greasy fried chicken. So,
Oh, come on up. I'll try and look for
He speaks good, he's your honor, but the young lady works on.
hi.
Good morning.
Who are you with relation to him?
We have Anthony here on the way, David McClure.
Who are you with him? Are you
Oh.
daughter, friend,
Sister.
his sister?
Yes, sir.
Okay. Do you solemnly swear to be able to translate everything word for word, ma'am?
Yes.
Okay. Good morning, Mr. Vo. Do you mind translating?
Yes.
please? Good morning, Mr. Vo. Okay. Do you have a lawyer?
Oh, sir.
Yes.
Who is your lawyer?
Everything McClure.
Who?
David McClure.
David McClure? Do you know if they're going to be here today?
Yeah, we're on the way.
Okay, they haven't filed any documents yet, so we don't know. But we will have you just wait over there, and when they come here, then we can talk more, okay? But do not leave. Okay? Please.
Yes, sir.
Thank you, ma'am. Hey, Vic. He says he has a lawyer.
Oh.
I know. Coming up, Mr. Terrell. Do you mind handing it to me, Melissa? Yeah, sign it, and then if you come up there real quick. Mr. Terrell, you left before signing it. I'm glad that you made it back. So what this is this is an order for protection that identifies Haley Otler as a protected individual. Sir, there are certain things that you can and cannot do. If you do that, you will incur another case, a violation of a protective order. It's one of the worst cases you can pick up. She is now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? Like I said, if you violate this, they will file an additional case against you. And it's one of the worst cases you can pick up in misdemeanor court. So just follow this thing. We will give you a copy so you know what you can and can't do. If you ever have any questions, talk to Yasha and he can also explain it for you.
So I already do have a copy of that as well from the house because I was already on a protective order when I got released on bond.
You may have it in the felony court, but you don't have it with us. And I want to make sure that if you pick up another case, because you do something like that, you're going to pick up one here too. That's why we do everything in tandem. I don't have it. And I want to make sure that you understand that that's why I have you, come here. I can explain it to you because forewarned is fair warned. Okay. All right, buddy. Come on. Take care. Good to go. Yeah. Smell like weed? Really? Did you smell the weed? You smelled it? I didn't smell it. I smell it now. I smell it now. Hey, Rachel, pop Mr. Terrell within the next week, will you? Yeah, next week. It's on page It's on bottom bit 27. Dude came in here reeking of weed. I didn't smell it till just now. Otherwise, I would have sent him.
Judge's appearance is waived next setting.
Okay, well, we're gonna send it for a test. And then when it gets positive, we'll get the BVR.
Right now, you're gonna send it?
No. Next week, pop.
Next week. Oh, so just print them and opt out.
Okay. Good morning. It's Daniel, right, Daniel? Dorsey, that's right. All right. So, Mr. Dorsey, you were placed on probation for terroristic threat.
Yes, sir.
It's come to our attention that you picked up a new case and you pled to that new case in, is it Tarrant County, right?
Sir, it is
Is it true or untrue that you violated your probation in this?
true.
Okay, I'm gonna find that's true. I will now reform your judgment. It will now reflect as a conviction on your record. The only other thing I'm gonna advise you is that be careful. I would not, because it's now reflecting as a conviction, I would be careful how you conduct yourself, because if you continue to do what you're doing here, you may very well end up with a felony case and you're looking at up to 10 years. So be very careful, Ms. Dorsey, okay? All right, so I'm going to sentence you to 180 days in jail. I'm sorry, 100 days in jail. I will give you credit for the 99 days that you've done. Good luck to you, sir.
Thank you, Judge.
Yeah.
Judge, I have Terrence Walker in the jury box. He said that he got drug tested today and that the results came back negative. And so he also wanted to ask about, they have him on random drug testing to call in. Do you still want him on that if he's getting drug tested twice a week?
Yeah.
Okay.
I guess it just doesn't make sense to do that, right?
Right. That's what I was thinking, Judge, because
I agree.
we have him on higher supervision, really. And I also have a Mr. Asamoah here, Judge. He just bonded out. I don't know if you remember him. I think it
I
was.
remember. Ms. Asamoah.
So, Judge, he's here. He's right over there. He got a notification on his phone to report today, even though it looks like he's been reset to August 30th. Can he get his bond conditions done today and get a reset?
Absolutely.
Have him come up, Judge. Mr. Asamoah?
You're 19, right? What are you doing with your life now, Mr. Asamoah? Are you working full-time? Why? At 19, you should be working 50 to 60 hours a week to work, to earn your keep or to get in school to better yourself.
Sign up to be in class for electrician.
Okay, you didn't get your GE, did you?
No, I graduated high school.
You did graduate high school? Okay, so we're working part-time at a car wash. I mean, is that what you want to do for the rest of your life? So tell me what you want to do. Quiet, it's too loud.
Electrician. Electrician. I want to be electrician.
That's a great idea. Dude, electricians can kill it. If you do a good job, if you're honest, you work hard. I mean, you start your own company, you can go work for another electrician, you know. If you truly want to do that, you need to become and go into the Brotherhood of Electrical Workers, right? Get into the union. The union will help you a lot, right? It helps you train, get jobs, get you on your feet so that you can be making 25 to, $50 an hour. Being an electrician, you can really kill it if you do a good job. So where do we go from here? Telling me you want to be an electrician is.
I already know about this site. I could they have this new, I don't know, it's like a new thing coming out. I could sign up to be an electrician for free.
Where?
I gotta go up to something.
Give me a second.
Please, you know.
I stepped down with telling me today, because he said, one of the colleges, another week, and they still make money for the class. Electrician.
And talk to family member on your case. I think they can do time served, or we can look into that. We need to make a decision, okay? No blood work in that case? I think the blood work is back, so let me take a look and talk about it. Okay. I think we should do that.
Yeah, he's every Monday.
Okay, so this is an employment services guide that I'm going to give you. Okay, one of these here is for young adults. This will help you. This is for young adults to help you trying to find a job, internships and the like. But you have to call them and make an appointment to get it done. Can you give this to him, please?
Yes, Judge.
I'm also going to test you 30 days from today. You know what happens if you test positive again. This time, I'm not going to double it. What I do the next time is I triple it. And then I quadruple it. And then I quintuple it. At some point, someone's going to stop ponying up the money to get you out. Stop smoking. Do you understand? You will be tested 31 days from today. You now know what happens. Now, I'm going to bring you back in 2 weeks. I want to know what you've done to get a job, a full-time job. More importantly, look into becoming an electrician. Get on it. You understand? Okay. See you in 2 weeks.
2 week reset on him, Judge? Okay, just gonna take a scan. And Judge, on Mr. Walker, can I do a 30-day or?
Yes, for you, yes. He still has the same.
Already
right.
coming in.
Yes. Yeah. But yeah, for you, so.
Thank you, Judge.
For sure.
Did you follow the date or report?
Hey. Okay.
You called
Yeah,
for,
it's for
Ventura Lopez?
Ventura Lopez.
Council for reset.
Mr. Ventura. I want you to understand, well, let me ask you this. Are you a United States citizen?
No.
Are you in this country with or without permission?
Sí, tengo 20 años de vida.
I've been living here 20 years.
That was not my
Esa
question.
no fue mi pregunta.
You in here with or without permission?
Without permission.
What happens if you go to jail?
Tengo mi familia sola.
I leave my family alone.
Yes.
Sí.
What else?
¿Qué más?
Pues mi madre que yo mantengo también.
I support my mother also.
Yo la mantengo en mi familia.
And
Mi
I
esposa.
support my wife and family.
Mr. Ventura,
Señor Ventura.
what happens if you go to jail?
Oh,
Are you in this country with or without permission?
País con o sin permiso.
sin permiso. No tengo permiso todavía.
Perdón.
No tengo permiso
I
todavía.
don't have permission yet.
So what happens if you go to jail?
¿Qué pasa? ¿Qué le puede pasar?
I'm trying to get you to think of what happens if you go to jail. I'm trying to get you to put one and one together.
No sé qué van a hacer.
I don't know what the United States would do.
Mr. Ventura, immigration sweeps the jail on a daily basis. And when they find people that are in jail without permission, they put immigration detainers on them. When you get an immigration detainer, you were stuck in custody until the case is over with. And then you were shipped off to immigration. Nothing fast happens in immigration. So you will sit in custody for probably 6 to 9 months, waiting for your life to have some kind of finality to it, which at that point you will probably be deported. All the while, your wife, your mother, your daughter, your puppy, your kitten, your pet parakeet will all have to find some other way to support themselves. And I'm going to tell you, that they may go to places that you do not like. So I am now putting conditions on your bond. And if you violate these conditions, I will put you in jail. And if you are unlucky enough, you're going to be there for the next 9 months. Do you understand?
Order in the court.
You are not to consume alcohol or illegal drugs. And I will test you. My main concern is that you do not drive. If you do not have a Texas driver license and you do not have liability insurance, then you're not to drive. And I will have you sign an affidavit with me today, which is a promise that you're not to drive. I don't care what's going on in your life. I don't care what you have to do. Until you have a Texas driver license and liability insurance and permission from us, you're not allowed to drive. And I'm going to tell you, nothing makes me more upset than when people get into a car and drive when I've had them sign this affidavit. Do you understand? You will be doing a substantial amount of time in jail if I find that you drive. I will give you a lawyer today. You can discuss your situation with your lawyer. But I'm gonna tell you now, what I'm doing to you now is I'm giving you a warning of what could happen to you. I see time and again how people don't heed this warning and then they end up in custody for the better part of a year.
Okay.
And we'll have you come up here, swear to us that you're not gonna drive. After that, you will go back to the jury box to fill that out. And then I will take a look at it to make sure that you qualify. If you do, we will provide you a lawyer today.
Si califican, le asignarían un abogado de oficio hoy.
Okay, please. Yes.
Coach Miguel Garcia, I believe he was clean today. We got his T-Raz back. He has expressed interest, or he did have interest in this.
Oh, hold on. He took a test today. Great job, Mr. Garcia.
I can't plead him to that. I'm not gonna plead him to that.
Okay.
He doesn't want to take it, I don't blame him. It's not
I
a
get
drug
it,
case,
but
but
that's what he needs, right? So, look, I'm not gonna fault you for doing it, right? I understand, right?
so I really don't have options other than trial at this point.
I agree, right? You know, we have clinicians that, Mom, you can come up too. We had clinicians evaluate him, okay? I can let you, and I will allow you to see this, and I'll allow you to read this, so you know exactly what they say, okay? Because I think that it's only fair that you get to see what they say about him. You lied here too. You lied in this thing too. Come on.
I was truthfully honest on it.
He reported his last cocaine use was on or about June 21, 2024.
That was the day before.
Essentially, what they're saying is that he needs to go into a treatment program. That's what they're saying is what he needs, an inpatient treatment program. How long is it?
6 months.
I'm sitting in jail for a year, Your Honor, and doing 4 months. I mean, it's, you know.
Say it again?
It's better off sitting in jail for a year and doing 4 months. He's gonna be in custody on this, going on this for 2 years. It's not even a drug case. I get he has an issue. I get it. But I mean,
Greg, you know this as much as I know this. You can address it now, or you can address it when he's 32, homeless, no teeth, just, you know, in and out of custody, because that's typically what happens.
I don't think this.
Did you read this?
I read it, but you know, they're sending 19-year-olds on what's not even a drug case to some freaking group home where you've got felons and everything else that's government funded. I mean, I don't think this is the environment for him, especially on this type of case. I understand he has a drug problem. I think it can be accomplished through IOP, I think it can be accomplished through continued AA, NA, extensive supervision, but you know, I don't think sending a 19-year-old to a 6-month program, which with a bunch of ex-cons that have been ordered by the felony courts and parole, is the environment for him to be in. That's what it is.
I can give you the opportunity if you want. We can do IOP, we can do SOP, okay? But if he mucks it up, that's what we'll use as the punishment.
Okay, let me talk to him.
And I'll agree with you, Greg. Look, he tested negative today. That makes me happy. It makes me happy. And I will give you the opportunity. I can pay for it for you, man. I will give you these tools for you free. I can pay for it for you now. If you try to do it on your own, it's $30,000 to $50,000. Whereas now I can give this to you for free.
But hasn't he been negative for like the past 3 tests?
I don't know. I'll have to check.
Like-
So that's why I'm saying, if he has,
I understand, but
Ms. Garcia, if he has, that's why I will give you the opportunity to do out in the free world now. It's intensive outpatient treatment program, followed by supportive outpatient treatment. I was forgetting what the S stands for. So it's like a double one after the other type piggyback situation where he's in treatment, but it's in the free world, right? We can do it. I'll acquiesce to you.
Okay,
As a sanction, as a punishment, if you ever test, and I don't care what the flip it is, you will go into inpatient treatment. They're saying now that's what you need. And I agree with them. That's what I think. Because of what this says and what you have become accustomed to and what you've put your body through, you need something more controlling, right?
I know this is a change, and I also been doing what you've been telling me to do, like the NA. I'm already going to school, and then I already did the job and everything you told me to do. It's already all at night. So the change is just the point of that.
No. You can either do this now, or you can do this when you're 46, 49, 52, God forbid 65, when you've literally been in and out of jail, robbing home after home, car after car to feed that addiction. We try to get to you now so you don't end up like one of those lowlifes. Quiet! Those people never had someone to put them over their knee and show them what happens with substance abuse, right? It only ends up in one way, and it's downhill. It never ends up well. Never. And if we don't tackle it now, if you don't tackle it now, your life's gonna suck. Even more. It only gets more difficult the older you get. It doesn't get easier. You get bigger, you get fatter, you lose your hair. Everyone wants to see you fail. And all the while, you have no money to help yourself. It doesn't get easier. It gets more difficult. I promise you. Now, I have the tools to help you. If you want it, it's here for you. So I'll acquiesce to you now.
Okay, let me talk.
You know, as a sanction, I'm putting him in the inpatient. So I don't care what it is, no tolerance. I will allow you to try to do it yourself. But, so I think it should be at least at the minimum, like an 18-month to 2-year, because that's what it's gonna take. Can I pay for IOP and SOP?
We can see if it qualifies for cap funding through us and then.
Yeah, please. And then I will waive all the fees for you for as much as I can so that you don't have to pay a dime. I don't think I can pay for everything, but for everything I can, I will. Okay?
You want me to reset it for now so we can check on this funding and they can make a decision? All right.
I'll have to do a financial update with this.
Okay, let me.
I'm hoping I don't think there'll be a problem other than
Okay.
wearing a damn Gucci belt that's $400. I mean, what the hell? Get a nicer belt than I do. Here, I have a freaking electrical wrapped around my waist and he's got some damn Gucci belt. Come on, man. That's not where your money belongs. Here, will you read this, Mom?
All right, let me run to a plea to another court and I'll get him
Take
to
your
a
time.
financial. Okay.
Fresh.
Okay.
Hey,
Good morning.
Good morning.
At 10 Vo, I think we need to approach on bond conditions. I believe.
is it a new case?
Relatively new, yeah.
I don't know. I don't think so. Let me see.
Okay.
Are you signing on now just for the first time?
I thought I was already on it, but they attached it.
I don't have anyone attached right. Let me just make sure. The computer's kind of slow. Sorry. Yeah, we don't, you said you filed an attorney record?
I went through the kiosk, but it wouldn't be the first time the kiosk
See something?
faulty.
On vote, bottom of page 30. Regardless, we've done conditions. You guys are free to go.
Okay, take it.
Sure, thanks.
Judge. Judge.
Hey,
Person on fugitive case.
Night, night, guys. See you maybe tomorrow. Tomorrow I might have an afternoon meeting, so unfortunately it can't be as predictable as a TV show. Thank you for hanging out. Welcome to the new members. Thank you for the super chats. This has been such a fun one.